his motion. No, he's letting it go first.
To the extent that you find Fry applicable, which is going to be the first one chapter.
First thing I agree with the best.
I'm here to please this morning.
There you go.
Steve.
Thank you, Hilly. Appreciate it.
Yes, sir. Always trying to help.
I want to start because the discussion has been presented, this argument has been presented, the notions that have been presented in the context of the Fry hearing. And I want to put Fry in context from the outset. As a general rule, in our criminal justice system, being an adversary system, regarding the admission of most evidence, how you test its reliability is through the crucible of cross-examination. It's not a question of whether or not the evidence is admissible. It's that the opponent has an opportunity to test its underpinnings, to challenge the witness. The idea behind Fry and the separate standard for scientific evidence and for new and novel methods of doing things in general is that when you're talking about something that is honestly new or novel, that the opponent of that evidence will not have an opportunity to properly test it because they don't understand the underpinnings. They don't know really what it's based on. And our court system says, regardless, in Florida it's Fry, in the federal system, for example, it's Daubert, but they're designed to do the same thing. Make the proponent of the evidence demonstrate its reliability. What are you basing it on? What's the science behind it? What's the method that you did? So that someone who doesn't know about this new concept, this new idea, has a legitimate opportunity to test it. Because when something is new and novel, like for example DNA in its infancy, you are looking always to try to find, where's the expert? What am I testing? How's it being done? What's electrophoresis? What's an allele? How am I supposed to know these things? So in the early stages, that's what you had to do. Put on basic scientific testimony and evidence to establish to a Fry standard that you did what you needed to do and you did it correctly so that the opponent of that evidence could listen to that, could evaluate the piece of evidence and say, you know what, I don't think it was done right. And I'll bet you I can find an expert, or I can cross-examine their expert, and I can find out. And that is the reason why you're not supposed to conduct a Fry inquiry unless the evidence that's being challenged is genuinely new and novel. So I've provided, we all exchanged case law earlier. I've given counsel for each of the defendants copies of what I'm going to give you. This is Charles Anderson v. State, Florida Supreme Court. It doesn't have anything other than a Westlaw site, 2017 Westlaw 930924, because the opinion is relatively new, March 9th of this year. And I've flipped and highlighted the only relevant portion that really talks about it. It is a restatement. It is one of the most recent restatements from our Supreme Court, basically indicating, as I said, that unless you're talking about a new and novel concept, Fry is not applicable. In that particular case, they were talking about grease stain patterns. And Anderson saying, I think you have to have, my lawyer was ineffective for not having a Fry hearing, not challenging the admissibility of the evidence. And the Supreme Court said, it's part of the broader concept of trace evidence. It's been around. The concept of how they do this kind of testing has been around for decades. It doesn't matter that there's no expert particularly dealing with grease. Everyone understands trace evidence. And so for that reason, it's not new and novel. A Fry hearing was not required, but they also added, pointing out specifically that Anderson had a full opportunity, because he understood trace evidence, to cross-examine and to bring out those things that he wanted to challenge regarding that evidence. Take a step back now to one of the more detailed opinions from the Florida Supreme Court, specifically dealing with the application of the Fry standard. This is Marsh, common spelling, value, V-A-L-Y-O-U, 977 Southern 2nd, 543. 2 points I want to make with respect to that case. And you'll see there are two clips there. On page 5 of the computerized opinion, that's actually citing from page 547 of the actual case. It talks about who has to carry the burden if Fry is there. And they say, by definition, the Fry standard applies only when an expert attempts to render an opinion that is based upon new or novel scientific techniques. And they cite earlier case law to that principle. And then they have this portion that I highlighted a little more extensively. Therefore, we have recognized that Fry is inapplicable in the vast majority of cases. And they cite another DCA case that most expert testimony is not subject to a Fry analysis. We move on, if you would, to that second area I have clipped, because I think this is going to be very instructive in terms of how the evidence was laid out in this hearing. The Florida Supreme Court makes very clear in the Marsh case that if you've established the science and the methodology, the opinion of the expert is not an issue. If that person is qualified to testify, the deductions that they made from the valid science is not a Fry inquiry. I'm going to quote from a portion of that opinion that cites to U.S. Sugar. It's actually a state case, 823 Southern 2nd at 110. It's been cited in several cases since it came out from the Supreme Court in 2002. And this is the language I want to rely on. Under Fry, the inquiry must focus only on the general acceptance of the scientific principles and methodologies upon which an expert relies in rendering his or her opinion. Certainly, the opinion of the testifying expert need not be generally accepted as well. Otherwise, the utility of expert testimony would be entirely erased, and opinion testimony would not be opinion at all. It would simply be recitation of recognized scientific principles to the fact finder. We reaffirm our dedication to Fry and talk about how you're not supposed to do that. Start of the second paragraph. Trial courts must resist the temptation to usurp the jury's role in evaluating the credibility of experts and choosing between legitimate but conflicting scientific views. The issue here again is the science, not the deductions of the individual expert regarding the science. How have they applied that in criminal cases? Just a couple of quick highlights, and then I want to go through the specific pieces of evidence. This is Rogers, 948 Southern 2nd, 655 from the Florida Supreme Court in 2006. Rogers is a death case. The issue referenced in the clipped and highlighted portion is about the admissibility of IQ scores. They use a test that is traditionally used for screening. It's not used normally to determine specific IQ, but the test has been around for a long time. It's established science. The defense challenges and says, we're not provided with enough information. You didn't use the test the way it was devised. You used it to determine IQ scores, not to use it as a screening device. You didn't tell us about the conditions under which you administered the test, and therefore it's not scientifically reliable. The Florida Supreme Court does their analysis, applying Fry, talking about the scientific, the application to scientific principles, and determines that notwithstanding the fact that the test was being used in a different way, and that they didn't know the conditions under which the test was specifically administered, that the science for the test was valid. Therefore, there was no basis to do a Fry inquiry. I take from that and talk about two other cases, I think, as part of the judicial notice motion that I filed, I cited for this case. This is Butler, 842 Southern 2nd, 817, an opinion from the Supreme Court in 2003. All this is a restatement from the motion that I previously filed that random match probability, random man, or the product rule, if you want to call it that, is scientifically acceptable under fraud. Subsequent thereto, you have the Thomas case from the first DCA in 2009.
Right.
Site is 22 Southern 3rd, 626. Thank you. Just going to read the portion that I highlighted into the record. We affirm as to the first issue because the trial court...
No.
Sorry. We affirm as to the first issue because the trial court properly found that the combined frequency analysis at issue was an extension of the product rule, which has been recognized in Florida as a generally accepted method of DNA calculations, citing the above. We affirm because it is an extension of an accepted scientific principle that has already been reaffirmed regarding fraud. Last case I want to talk about before we get to what the evidence actually demonstrated during the course of this hearing. There has been a good deal of discussion about the application of science in law in this hearing. I'm thinking particularly as it relates to the idea of the group hypothesis and what you can do and what you can't. And this idea that has been proposed, I would argue, by the defense, that science, assigned with the task of answering the question and determining the reliability of the answer, now, suddenly, can tell us what question to ask. That they can set limits. That they can determine for us what the probative value of evidence is. I take issue with that, and so does the 4th DCA. Minkins, for the record, is M-I-C-K-E-N-S, 121 Southern 3rd, 563. I highlighted a portion of the case which turns out to be a significantly large enough portion that I probably should have just left you the case and said, just read it. Because it has a number of applications to the specific scenario that we're dealing with here. And it cites to earlier Florida Supreme Court cases, and for record purposes I want to put the site in there, of the Walker case. One of the arguments that the defense makes in Minkins is that because the statistical probability is so low, you can't call it a match. Don't say match. And that the evidence doesn't really identify anybody. It's not qualitative enough. The defense cited a federal case for that proposition, the Natson case. This is the 4th DCA distinguishing federal authority on this point.
Which is Natson?
Natson, N-A-T-S-O-N. Unlike the Natson court, the Florida Supreme Court has been more lenient in allowing the admission of scientific tests which do not conclusively identify a defendant. In Walker v. State, 707 Southern 2nd, 300, that's a Florida Supreme Court opinion from 1997, the defendant was charged with murdering a woman who had accused him of fathering a child with her. DNA was recovered from a cigarette butt found in the victim's car, and testimony was introduced that the DNA was of a type shared by the defendant, the defendant's brother, and 12.2% of the African American population, 6% of the Caucasian population, 4.8% of the Hispanic population. The defendant argued this testimony was not relevant to any fact at issue in this case because it did not prove the defendant or his brother were present in the car. The court rejected this argument, knowing that it had previously allowed the admission of blood test evidence, which showed only that the defendant and the tested item had the same general blood type. Any concerns about the probative value of the DNA evidence went to the weight of the evidence and not its admissibility. Why it matters in terms of what a court decides for probative value If you have to prove a defendant's involvement in a capital homicide, that blood was recovered from the scene, and the defendant had a rare blood type that was still shared with 12% of the population, and that's your proof. That's not going to be admitted, assuming for the sake of argument that you can even get past a directed verdict, which I think we could all agree you can't. But when determining the probative value of evidence pursuant to the Florida Evidence Code, under 90.402, the standard for basic relevancy, you are considering all of the pieces in total in making a determination regarding probative value. So the suggestion from the defense that science can drive the question to be asked is rejected by our courts. It's the courts that decide the question. What is the probative value? And I leave with that and move on to the specific evidence as it was laid out in this hearing. There are some very specific propositions that were put forth, and I just want to address aspects of them in terms of what the evidence demonstrates. Before I leave the topic, I'll come back to it. There's an issue regarding the National Research Council I want to address, but I'll wrap up with that. All right, first argument from the motions, and I'm taking this from language from Mr. Maldoff's motion, that assessing the electropherograms was done improperly because they were looking at reference standards at the time that they made this being Dr. McElfresh and Dr. Tracy at the time they made their assessments. Dr. McElfresh testified in detail how he cataloged the evidence sample first. He supported that testimony with 30 years of experience in the field. He knows the machine that was used in this case. He's validated them. He's had as many as 30 of those types of machines up when he was a chief science officer at Bodie. He explained how he assessed the peaks for height, shape, and location, how he considered all of the data, and that he felt his first obligation was to consider the issue of exclusion, and that he did all of that before he ever looked at a reference sample. That's consistent with Dr. Tracy's testimony in terms of how he made his assessment of the electropherogram before he looked at the reference sample. Notably, not a single witness, not Dr. McElfresh, not Dr. Tracy, not Mr. Keel, not Ms. Roy, not Ms. Heather Eric LaSalle, gave any testimony indicating at any point that they were using the reference standard when they were determining what loci to look at or what alleles to call. There's none of that in this record. There is testimony from a defense expert who opined, it was her opinion, that the witnesses in this case who said they did not do that, in fact, in her opinion, did that. I think in some instances she went so far as to say they were clairvoyant. I will come back to that. The record, however, indicates very clearly that they did not. There was some suggestion from Ms. Roy that aside from this question of looking at the reference samples initially, that you should look at the reference sample only after you do all your calculations. Don't even look at the issue of exclusion. Just start doing math. The NRC doesn't say that. Swig-Dam doesn't say that. In fact, the guidelines, the 2017 guidelines that the defense put in, point out, and this is, I think when we were doing the hearing, Mr. Moldoff asked regarding page 56, talking about likelihood ratios. This is from the 2017 Swig-Dam guidelines. This question about considering people of interest together in a mix, they point out you can't even do it. It's impossible to do without looking at the reference sample after you've cataloged all the information. Of course you're going to consider the reference sample and determine the question before you do the calculation. Otherwise you're doing unnecessary calculations because you could be excluding that individual. None of the evidence supports the claim. What about considering data below the 150 RFU threshold that was testified to regarding the BSO genetic analyzer in the initial stage. Alan Keel, retained by the defense, retained by Mr. Forbes, testified to the use of 50 RFUs as an analytical standard as not only being scientifically sound, but proper and consistent under National Research Council guidelines, NRC guidelines. And that was the reason why I was hunting around for the one case I'll give you as I conclude, that the Florida Supreme Court has already indicated that where the National Research Council recommends, endorses, or permits a standard, it's FLI compliant. Dr. McElfresh explained in detail on his rebuttal testimony about exactly how he calculates you can calculate an analytical threshold based on noise levels. He supported his conclusion citing to the Swig-Dam guidelines endorsed by Ms. Roy that 2 times the noise peak, 50 RFUs is above it. He confirmed Keel's testimony about the scientific reliability of using 50 RFUs. Dr. Tracy found it acceptable. Heather Eric LaSalle, who testified, now working for the FBI, I believe her testimony, I don't remember having the physical copy of it, but I have it in my notes. Not only did she say that many labs use 50 RFUs as an analytical threshold, I think she said the FBI uses 50 RFUs as an analytical threshold. All consistent based on your ability to assess where the noise is, all consistent with the Swig-Dam guidelines. Keel says it's scientifically acceptable and consistent with the NRC. McElfresh agrees with him. The Swig-Dam guidelines explain how to do it, and Ms. Roy testified those are the guidelines she uses. There's absolutely nothing to support an argument that it is unscientific to make evaluations at a 50 RFU level. Petros and Dallas came in from the lab. What do you set your instruments at? What are they validated at? 150 RFUs. On cross-examination, Mr. Marcus asks, are you saying that going below 150 RFUs is not scientifically sound? No. I'm talking only about my requirements, my rules. Do you go below 150 RFUs to look for data? For exclusion, for example? Yeah. Yes, I did. And he won't be critical of any other expert's work at 50 RFUs. He talks about his own standard at the BSO lab. Ms. Roy's testimony criticizing the 50 RFU standard said it was based on the absence of validation. But she endorses the same Swig-Dam guidelines that Dr. McElfresh explained regarding how you can make a determination based on the noise level to make sure your analytical threshold and your consideration of evaluations at 50 RFUs are scientifically sound. This is a disagreement between experts, according to Ms. Roy, regarding how they deduce what they deduce from what is otherwise reliable science. It is not fraud. Next challenge. Wrong conclusions in calling a major profile. And there was some discussion, particularly as it relates to GEO 29A. Again, more disagreement over deductions from the science. Dr. McElfresh explains his procedure. It's the same procedure he's used for decades in calling a major, in terms of looking at the peaks. I asked him, we put into evidence the Swig-Dam guidelines from 2010. 3.5. Following the guidelines, endorsed by the defense expert, Ms. Roy, he called a major inconsistent with those guidelines. They don't like the result. Ms. Roy disagrees. Following the same guidelines, same rules, she says, no, it's not something you should call. They argue. The defense argues. Well,
I'm just going to object. You keep on saying that the defense expert, we did not call Ms. Roy.
Judge, For record purposes, I have no problem referring very specifically to Ms. Roy as Forbes' expert, instead of just calling it defense in general. I'm fine with that.
Delancy.
Regarding,
Excuse me?
Delancy adopts that.
fair enough. I think it's pretty clear what both Delancey and Mr. Delancey and Mr. Ingram think regarding that issue, and we'll leave it at that. So, Heather Eric was out. She didn't call a major at GEO 29A. But when questioned about it, she said she didn't feel comfortable making that call, but she understood that another analyst might very well feel comfortable making that call. She took no issue with those who called GEO 29A a major. One of whom, along with Dr. McElfresh and Dr. Tracy, happens to be Alan Keel, an expert retained by Mr. Forbes, one of the defendants in this case. I think it's important as we start breaking this down to remember how many times even Ms. Roy told us that disagreements between scientists, between experts, does not make the science unsound, does not make the methodology unsound. Disagreement, not fried. Science is sound. The deductions are disagreed on. Random match probability calculations. I put this under as one of the issues to discuss, although I believe each of the defendants has told the court at one time or another regarding the Fry standard application to just random match that they take no issue with it. But you have the Butler case, you have the cases that follow from it, including that first DCA case from 2009, making very clear that our courts have specifically found that random match calculations for DNA statistics is Fry compliant. Challenge to the likelihood ratios in general as not being accepted. Not getting into the issue of the group hypothesis, just talking about the formulas themselves. Mr. Keel said, scientifically sound. What did he support it with? National Research Council. Dr. McElfresh said, scientifically sound. What did he support it with? The National Research Council. Dr. Tracy said, they're scientifically sound. What did he support it with? The National Research Council. Heather Eric LaSalle explained over Skype about how likelihood ratios have been used for at least 2 decades in calculations properly in lawsuits over the issue of paternity. Has no problem with the scientific reliability, believes it to be sound. There is nothing to support a suggestion that likelihood ratios are anything other than Fry compliant without further need for explanation, expert testimony, or otherwise. They're NRC compliant, they're Fry compliant. There was no need to hold a hearing to make that determination.
I'm just going to object to that in that we never alleged that likelihood ratio was invalid.
And I'm happy to have that admission on the record. So we'll move from there to the question of the group hypothesis. Suggestion that the idea of including a group of people in your likelihood ratio, people of interest, as the doctors did in this case, regarding, in some instances, all 3 defendants along with Mr. Ingraham's son. What did the testimony establish? Where does the idea of a group hypothesis for people of interest for your calculations come from? Straight out of the guidelines from the National Research Council. The Swigdam guidelines, even the 2017 version, going right back to them. And this is from page 56 of those guidelines. The LR, likelihood ratio, may also be used to assess the DNA findings given multiple POI, which I believe they defined earlier as persons of interest, together in a mixture. Together in a mixture. So the defense says, you can't do it. That's not a proper way to do it. You really have to break these people out. This goes first to that argument I was talking about before when I said, now all of a sudden, scientists are going to tell courts what questions you can ask. I'm not asking. The prosecution is not interested in the inquiry about one. We want to know what's the likelihood of them all being there together. That's the point of asking the question. The defense says it's an improper question to ask. Does it have probative value? Can I argue that it has probative value? Very clearly I can. It's a group hypothesis that's endorsed by the NRC, endorsed by Swigdam. So it's going to overweight. It's going to overweight and be unfair to some defendants. So I posed an example. I asked a question of Dr. McElfresh on the stand of rebuttal yesterday. So here's your example. I got A, B, C, and D. A and B are at 6 loci. You multiply 6 loci, assuming for my example that they're all relatively weighted the same. 6 is going to give you a decent number. But C and D, they're only at 3 loci. So I argued with Dr. McElfresh on the prosecution. I want all 6. I want the number that's going to be the highest number. I asked him, please, use all the guidelines, all the rules, everything you can, everything short of putting your thumb on the scale, and tell me how I can get to 6 into that equation. And he said, you can't and I won't, because that would overweight the evidence. I'm only going to count the loci where they all exist together. Perfectly consistent with those things set forth by the National Research Council and the language from the NRC guidelines. So, Ms. Roy says she had communications with Dr. Peter Gill, who is a renowned, that's what the testimony is, a renowned scientist, and I have no reason to dispute that. He certainly contributed to the creation of software associated with LR-Mix and LR-Mix Studio. And in the course of that communication, with whatever information Ms. Roy provided, and I think we did have emails that were put in, she got an answer from Dr. Peter Gill that you shouldn't do this. Never mind NRC or Swigdam. You shouldn't do this. It's not fair. So that's the communication when Tiffany Roy has it. But the same renowned expert in the field has written on the topic. And when he is not having information provided to him by Ms. Roy, writes an article and says there's nothing wrong. I'm going to come back to that when we get to the next part about LR-Mix Studio. I think it's important to note that when Ms. Roy was providing information to Dr. Gill, he came to a conclusion that appears to be contrary to his published work. Regarding the defense's suggestion that on the group hypothesis, you don't get a qualitative number for my claim. That's true. That's only true because that question is not being asked. The proper probative question is being asked about collectively the entire group. That's what I want to know. That's the answer I'm seeking, and I do get a number, and it is qualitative. Go to the LR-Mix Studio program. Dr. McElfresh explained exactly how he did. Talked about it in direct, when Mr. Sapp questioned him, went into even further detail and rebuttal when I questioned him. He said the same method of calculation, the same way he does the math, when he has a pocket calculator. Now, admittedly, we're all about to see, he's got a pretty fancy calculator on his phone, something better than my rudimentary calculator, but a calculator nonetheless. He does the same calculations on LR Mix Studio. He used it as a calculator. He explained how he validated it as a calculator. Alan Keel, an expert retained by Mr. Forbes to do analysis, was asked in this hearing about that process, about the use of LR Mix Studio as a calculator. He was asked if you use it for a purpose other than for which it was designed. And his answers? Sure. Not a problem. Just validate it the way you used it. How did they use it? They used it as a calculator. Dr. McElfresh, did you validate the way you were using it as a calculator? Yes. Dr. Tracy, did you do it? Yes. Heather Eric LaSalle, called by the defense in this hearing regarding this issue of using LR Mix Studio. Can you use probabilistic genotyping software, which is what LR Mix Studio is, can you use it in some other fashion? Had no problem. Dr. Tracy went so far as to point out that the use of LR Mix Studio as a calculator the way he did it is consistent with NRC guidelines. But Dr. Gill wrote a letter, oh, I'm sorry, I don't mean a letter, I mean a report about this case, and we have the emails. So I asked Dr. McElfresh the report, the I don't know how many pages, it's a 4 or 5 page report that was done on the use of LR Mix Studio, written by Dr. Gill. Where does it say in there you can't use this as a calculator? Couldn't find it. So then it was left to Mr. Moloff and to anyone else who chose to make the inquiry, show us where in the report it says that. What's the answer back? Check the emails. You can devise it from the emails. The report doesn't say it, certainly the emails do, that he disavows this use in this communication. This is why I think it's important to assess, when they were talking about the group hypothesis, that when Ms. Roy is providing information to Dr. Gill, he said one thing, but his published work said otherwise. I'm not calling anything into question with respect to Dr. Gill. He's a renowned scientist. But like everyone, intentional or otherwise, without casting a single aspersion, how you tell someone a story has an impact on how they assess the information. And we know how that's done because we have the benefit of the group hypothesis to guide us in terms of how he makes his assessments, about how Dr. Gill makes his assessments regarding the use of LR Mix Studio. And you have that report. The report he writes after the fact, after those communications, and you can read it for yourself, regarding where and how, if at all, he disavows the use of LR Mix Studio as a calculator, despite the fact that all the other witnesses who testified, including Mr. Keel and Heather Eric LaSalle, don't have that problem. I want to close with this thought. There is no testimony in this record. There is no argument. In fact, Mr. Moldoff reminded us again that we are to confine ourselves to the motions in this case. Nowhere does it say that any aspect of the process in the creation of the electropherograms are at issue. This is about reading the electropherograms and making determinations concerning what alleles to call at what loads. There are guidelines. The guidelines have been testified to by all as being scientific. What is at issue what has been discussed, what has been debated, what is the sole focus of everything that has happened here for basically a month, is an argument over deductions on a valid science where experts disagree. That is not a fraud inquiry. That is not a basis for exclusion. That is a basis to cross-examine, to determine the issue of weight. It is not a question of admissibility. The National Research Council, one of the last examples I gave, was to do between the state of New York and the state of California. You can say it's more than 2,000, you can say it's more than 1,000, and you can say it's more than 100. We can argue all day long, and I will tell you that I believe we did for a month, about whether it's better to say it's 1,500 as opposed to 2,000. That is not fraud. That is not a basis to exclude evidence. And for those reasons, these motions collectively and individually should be respectfully denied.
Thank you, Mr. Rapp. Let's just take a couple of minutes and pick up.
Having adopted NRC as a method for establishing fraud, for the record, the case is Henry, H-E-N-Y-A-R-D, 689, Southern 2nd, 239.
Henry versus state. Mercy can be given by the jury.
Well, not everything about it is fabulous.
And before we break for lunch, where's Mr. Williams? Did you file any motions with regard to this issue?
No, I adopted everybody else's.
Okay. So.
And I've relinquished the floor to Mr. Mullo.
Okay. I just wanted to make sure.
I asked him that. Do you want to just start and like get some groundwork out of the way? Whatever you want.
Why don't we come back at 1:15?
Whatever you want.
Sounds like a plan.
I've got 3 so far.
Yeah.
Scott, what was that last case? What was the last name of the last case that you just gave?
689, Southern 2nd, 239.
Okay.
All this time you couldn't get prepared to have water there?
Where's my water? Oh, no, it's over here. Up here it is.
Sure. Yep.
Restitution order. 130.
So, to begin with, I will say that what Mr. Rapp just argued is similar to what I thought happened a lot in the case, which is, it seems like the state is ignoring what this case is really about and much of their arguments, I assume, has to be intentional. I outlined yesterday that my motion directs itself directly to the motion designed to question the scientific reliability of interpretation of complex mixed DNA samples. There's 4 questions that are proposed in my motion. They're as follows. 1, Dr. McElfresh and Tracy used probabilistic genotyping software, LR-Mix Studio, to generate statistics without performing internal validation required by industry standards. 2, LR-Mix software was used improperly by Dr. McElfresh and Dr. Tracy when generating the statistics. Proper usage described in the literature reference in the LR-Mix manual. 3, the interpretation suggested by Dr. Tracy and McElfresh in their deposition testimony and notes is biased and falsely conditions the defendant as a known contributor to DNA mixtures before the experts evaluated the question sample for suitability to compare known DNA standards. And 4, the additional profile interpretation and statistical calculations that suggested by Drs. Tracy and McElfresh in deposition, they have insufficient training and experience for rendering, and it's not supported by reliable scientific principles and methods. So nowhere have we ever said to the court, and never said to the state, product rule doesn't apply, likelihood ratio is not a genuine, valid scientific method used in DNA analysis. None of the things the state argued about that have we ever averred or argued or suggested or questioned at all. And going back, Mr. Satz spent an enormous amount of time going through every calculation that Ms. Roy agreed with random match probability. The only random match probability right now that, well, one of the only ones, but certainly very few that we even contest, and the main one we contest is RC1A, which I'll get to later on in this argument. So first I want to talk to the court about the case law, because I think it'll outline our argument somewhat too. And again, it draws me back to Mr. Raff's argument to you, which cited maybe one case dealing with DNA. And it's interesting, because we all know Mr. Raff is a very smart gentleman. Hats off to him. Like I said, I've told him many times, Judge Kaplan used to call him the state's secret weapon. And aptly so, because he's versed in the law, very versed in the law. So in my memorandum, we cited numerous cases. I'm going to start with Brim versus State, 695 Southern 2nd, 268, Supreme Court of Florida.
So you already gave me a full package with all of your cases.
Yes, yes, they're all in. So Brimford, and there's a memo of law attached to my my motion. And again, when you asked for further memos, I'm going to rely on this because as I read it over last night and in the last couple of weeks, it really does summarize what our position is, albeit I have a case or two that I'm going to mention today that isn't in here, and so to that extent I am supplementing it. Let's just talk about Brim v. State. So Brim v. State is back in 97, I'm sorry, January 16th, 1997, and it's a case directly on point with our motion. It's directly on point because the question in that case, they had for review the lower court cases, the district court cases. And the question in that case, or what happened in that case, is there was DNA population frequency statistics that were offered into evidence, and the court was reviewing the district court opinion that said once the DNA testing is sufficiently established to be scientific, the statistics kind of come within the purview of that, and that's not required to have a second step, if you will, of its own scientific reliability. And in Brim, the court ruled, well, the court mentioned this numerous times. On page 7 of my case, it's actually 271 of the opinion in the Supreme Court before it. The dual conclusion reached by the district court requires us to clarify two distinct issues. First, we reiterate that newer novel scientific evidence presented from both steps of the DNA testing process must satisfy the Frye test. Second, we address whether multiple statistical calculations might simultaneously be able to satisfy the Frye test. Exactly what we're doing here. And they talk about NRC, and this is interesting because NRC, back in 97, this was a case that dealt with NRC, and they comment, they say, we acknowledge that arguments have been made that the statistics or population genetics used in calculating population frequency estimates are not new or novel scientific evidence and consequently should not be Fry analysis, was the lower opinion. They say, we disagree. And they cite the NRC. So NRC was dealing with this back in 1996 and 95. But to kind of jump ahead a little bit, and I'll get to it later, but when Mr. Raff suggested this court, you know, this is about things they've been doing forever, and NRC's been doing like-to-good ratio forever. That's completely true. But I think a good analogy to this, someone else gave this, I didn't hear it myself. A good analogy to this is, this science is evolving not rapidly like overnight, but rapidly in terms of, and significantly in terms of, in a decade or two, the science changes 100%. So if you think about when we all grew up in school, and we were talking about the 9 planets, and went through all that, and for time immemorial to us, there's 9 planets. Lo and behold, 60 years later, you come to find out, because of advances in science, Pluto's not a planet.
Not in my world.
Okay.
It's still there.
Okay. It's there, but it's not a planet. But the reason it's not a planet, and if you think about that, it mirrors right to this case, is because groups of scientists have debated that topic apparently for the last like 8 or 9 years or 10 years. And finally, scientific opinion changed and said, no, the bulk of the scientists agree. Like you say, a lot of the older scientists, ergo older statisticians, stick to the old way and can't get their head around it. But that's why we're here. Because in Brim, they talk about the standard of determining for Fry, like Mr. Raff says, Fry doesn't apply here. It's not even a Fry question. That's so not true. What it is in Brim in 96, they're saying this is a Fry test. This has to be a Fry test. And I'm quoting again. They say, we heed NRC's warnings that we should be cautious when using standard statistical principles in the field of DNA testing. In the absence of an independent validation method, we find that the Fry test is appropriate when using statistics or population genetics to calculate population frequency statistics. Consequently, the techniques and methods utilized in both steps of DNA analysis testing process must satisfy the Fry test. This standard, and I'm jumping ahead, I'm not just reading from the entire opinion, but they say this standard requires a determination by the judge that the basic underlying principles of scientific evidence have been sufficiently tested and accepted in the relevant scientific community. To that end, we have expressly held the trial judge must treat new or novel scientific evidence as a matter of admissibility for the judge rather than a matter of weight for the jury. And they quote to Ramirez, which I'll get to later. So they go on to say, and I'm just going to paraphrase a little, that's on page 9, but they reiterate, they say, they should not treat population frequency statistics as an extension of the first test. Those statistics are a distinct step in DNA testing process. They find the district court was incorrect when it said it wasn't. And they go on to hold, they go on to analyze really the statistical calculation methods. And they're talking about now the 96 NRC report. This is on page 10 of the opinion that I have, 274, the Supreme Court opinion. The NRC report. It recommends specific calculation methods. As a result, the trial judge still plays an important role in determining the admissibility of population frequency statistics under Fry. While we acknowledge that multiple statistics might be presented to the jury, the underlying principle used to calculate those statistics must be generally accepted in the relevant scientific community. And they say there's good reasons why that determination should not just, the general acceptance should not just be left to the discretion of the trial court. It's in the paragraph below the intended paragraph. What they're saying is, the general acceptance in the community is what you have to judge before you can even let this matter go to a jury. So they disapprove the district court opinion below, and they find that this distinct step, this is back in 96, and this was like the first opinion on this. So from 96, yeah, we're 19 years later, but that's the first time you had a court, no, 21 years later. Okay. That's the first time you had a Supreme Court for sure, because Brim was like 3, 4 Brim, 5 Brim. That's the first time the Supreme Court really saying that's the standard. This statistical second step needs to have its own Frye determination. Interesting that Mr. Raff doesn't even address Brim with you, saying, oh, you don't have to do this. This has been going on ad infinitum. We're really not. 21 years ago was the first time they even told the courts you have to look at the second step. So in Ramirez, and Ramirez is a case that they use to that I use just to illuminate this Frye standard, if you will. Because in Ramirez, it's an odd case, but it's a case where a defendant stabs an individual, and an expert comes to testify that he can determine, as a state expert, that the knife that was used was the exact knife that the defendant possessed by the stab marks in the victim. And they say that although he said that, and although the state had a couple of experts who sort of opined that was a good science, they said the record does not show Hart's methodology, Hart is the expert, and particularly his claim of infallibility has ever been formally tested or otherwise verified.
Do me a favor, put the site on the record.
I'm sorry.
That's
Ramirez, yeah, Ramirez, R-A-M-I-R-E-Z. It's 810 Southern 2nd, 836. Supreme Court of Florida, 2001.
Hart, H-A-R-T.
H-A-R-T. Yeah. So, and what they hold here is, and this is on page 10 of the opinion, talking about applying the Frye test. It says that for the court, it's not take a nose count. They say the court's not required to accept a nose count of experts in the field. It says the court may peruse disparate sources, expert testimony, scientific and legal publications, judicial opinions. They go on, they say, the bold assertion by the expert that his deduction is premised on well-recognized scientific principles is inadequate to establish its admissibility if the witness's application of these principles is untested and lacks indicia of acceptability. And I suggest to the court, not that Dr. McElfresh is not a smart man, and I'm not suggesting that he's coming in here and doesn't know what he's talking about. I think he knows what he's talking about in DNA. I think he ran Bodie Lab. I think everything he said is true, except for when we get to where we are today, which is 30 years post what he learned, and in an era of scientific reliability as it relates to population genetics, in an era when software, probabilistic genotyping software, is now becoming the standard, and he's just clearly behind the times on that. It's not really an insult to him, it's just a fact of life. He is the older scientist, he is holding on to some older concepts. But to the extent it impacts him here, I want the court to, in a minute I'm going to go through this a little bit with he and Tracy, but important to bring out is, well, you know what, I'll touch on it later. Let me follow up. So the next case I want to draw your attention to is Hillary. And that's People of the State of New York versus Hillary. And I have it as, you know what, I don't have the site somehow, but I'll get it. I'll get it from the court. The decision in order is IND number 2015-15, and it's the decision that was rendered in 2015. I'm sorry, it was rendered in 2016, I believe. So it's a very, August 26, 2016. The reason it's important is not so much that it's precedent for the court, but what happened there is the New York State Police had some DNA evidence that they wanted to examine. And when they examined the evidence, what they did was the New York State Police crime lab processed the samples and gathered DNA. When the New York State Police processed the samples, There was some work done, but it wasn't sufficient. So the New York State Police then hired this Institute of Environmental Science, ESR, and ESR possessed this STR mix, the gold standard, if you will, right now of probabilistic genotyping software. And they gave them the evidence and asked ESR to run it. ESR runs it and comes back with an opinion that I believe it was that the defendant's DNA is present or could not be ruled out or could not be excluded. And that's really not so important what their conclusion was. And Dr. Buckleton, who you remember Ms. Roy referenced, is the expert on STR mix that was called to the hearing in the Hillary case. And Dr. Buckleton conceded that no internal validation studies were performed by the New York State Police Crime Lab when they collected the evidence. They did not have any validation for the collection of evidence for the use by STR mix. This is on page 3 of the opinion of Hillary. So as a result, Dr. Buckleton was forced to pick and choose data from different reliable sources and input parameters into the program in such a way that he believed the system would tolerate. The reason for this was the New York State Police Crime Lab was not authorized by the New York State Commission on Forensic Science to generate data.
You have to slow down.
I'm sorry.
Not authorized by who?
By the New York State Commission on Forensic Science to generate data from DNA samples for STR mix. On page 5. You see here the only data generated was from the New York State Police Crime Lab, and the data was not generated by ESR. They say the Commission requires laboratories to comply with the standards promulgated by the American Society of Crime Laboratory Directors, ASCLD. These standards require that DNA mixture interpretations be based on validation data. This is on page 6, second paragraph. Here, by sending its raw data to ESR, an accredited lab for STR mix analysis, the people argue the New York State Police Crime Lab could bypass Commission approval for its participation in the STR mix process inasmuch as it did not run the computer program. The court was on page 7 to say, as stated by this court in its earlier order, the Fry test poses the question of whether the accepted techniques, when properly performed, generate results accepted as reliable within the scientific community generally. Based upon a review of the record, this court finds that STR mix has been developmentally validated and is generally accepted as reliable developmentally validated and is generally accepted as reliable within the scientific community. Over on page 8, they say the issue now shifts to the second phase, admissibility of the specific evidence, the trial foundation, and elements of how the sample was acquired. Once Fry has been satisfied, the question is whether the accepted techniques were employed by experts in the case. Here, the lack of internal validation by the New York State Police Crime Lab, as candidly admitted by Dr. Buckleton, precludes the use of STR mix results from ESR. So what you have here in 2016 is the New York court disallowing DNA evidence when everything is sound. The STR mix is developmentally validated, internally validated by the ESR lab. But where the data it's been given has not been also internally validated by New York State Crime Lab for use in STR mix, just that one matter makes it unacceptable for analysis using the acceptable developmentally validated STR mix genotype software. And the state wants to come in here and say to you, when we're talking about LR mix and internal validation, hogwash. This guy says it's a copulator. I mean, nothing in this case is even close to how obnoxious that is, or how arrogant that is. This is a lab that's doing its work properly. New York State Crime Lab is doing its work properly within its own standards, and ESR is absolutely working properly, but just the fact that they all were not validated independently Forget about as what, as a calculator, not just as what it's supposed to be. Because they weren't validated, that evidence is inadmissible. That's how important I submit to the court this scientific evidence has become, and how really difficult it is to understand. Because all of us as lawyers, when I read the Hillary opinion, I'm thinking to myself, I would never think of coming up with that argument as a lawyer if I worked here for 100 years. I would have missed that point. Who would ever? I'd have to have an expert doing everything for me, and that's why we have our experts. But that's something I would have entirely missed. But at least it's important to know, because it just shows how minutia can be very important in this, and I'm going to tie it up with our case in a short amount of time. The last case I gave you is Cassius, which is a 2012 opinion out of Florida, 2nd District, CASIAS, 94 Southern 3rd, 611, which deals with scientific evidence, and the scientific evidence at issue was analysis of DNA collected from the scene of a burglary and comparison to the known sample from Cassius. They say, because Butler and Grimm require application of the Fry test of general acceptance within the scientific community. This is on page 2 of the opinion that I gave you. It's actually page 613, I guess. Page 2, left-hand column, headnote number 4. Yes, sir. It is not sufficient for an expert to testify merely to the results of a statistical analysis. Instead, the expert must also testify to the methodology he or she used to apply the information obtained from that database to the DNA profile at issue in the case, so that the court can determine whether the methodology actually used is generally accepted within the scientific community. And if you go over to page 4 of the opinion,
My page 4 is just questions and answers.
Is it? Let me just think, maybe I don't have. Here, let me let you have mine, because I have another copy. It's here, it's this paragraph. I have another copy. Maybe yours. Maybe, did yours get cut out? It's the same
No, I
paragraph.
have it. It's just on the next page. There you go.
That's okay, I have another one. It says, Cassius's challenge to Johnson's testimony, Johnson's the expert, implicates both the second and third threshold issues. The record is clear the state never offered any evidence as to what methodology Johnson used to generate her statistical analysis. Ipso facto, there was no evidence presented to address whether that methodology was generally accepted in the scientific community. Without such evidence, the trial court, whose gatekeeping role required to determine whether the methodology used to generate the statistical analysis satisfied the Fry test, citing Grimm, simply had no basis to do so. So with that said, I want to turn now to the evidence. So let's look at this case now. It's kind of from an overview, if you will, because I know at times, we've talked about a lot of things. This case is about the question of the acceptability of the work done by population geneticists as it relates to offering statistical weight for samples of complex mixtures. Only complex mixtures, not single source, just complex mixtures, not a single source DNA sample. And to an extent that has to do with the underlying VSO data, where it was generated in 2006, because there is some real concern about that. And let me just start there with this, because I'm going to be arguing for the rest of my argument that Drs. Tracy and McElfresh have never established the scientific reliability under the Fry test that is generally accepted in the scientific community of what they've done here, as outlined in my motion 1, 2, 3, and 4. So the state says, well, we call Ms. Roy, who has a differing opinion, and they sort of want to make this like he cites you this case about, you know, trace evidence and grease, and, you know, it's been going on forever. That's true, and that's why grease and trace evidence has nothing to do with what we're doing, like I just outlined in Grimm, Hillary, Cassius. When you're talking about 10 years ago, we never even thought, no court ever even thought to look at the second part of the DNA analysis, i.e. the statistical weight, as requiring fraud. So 20 years ago, that was a new, completely brand new idea. And what's happened is, it's not like 20 years later we're dealing with the same question of the admissibility of the statistical second part of that test. We're now dealing with it as, like Ms. Roy testified, within the last 10 years is the first time we've seen, and even their expert agrees, probabilistic genotyping software. So 10 years ago, there was no LR Mix Studio, there was no STR Mix. So all of this that we're dealing with is really doing with probabilistic genotyping software, because that's the heart of what our complaint is as it relates to their use of the LR Mix Studio. So let's contrast general acceptance for the moment in the scientific community of Ms. Roy. You've said to me, you know, why are we doing this in the middle of trial? You know, because why didn't we do this earlier? Why are we doing this motion so late in the game? The reason is pretty simple. I can tell you, as a lawyer, I never really concentrated much on statistics either. I mean, I maybe read Grimm, but I never understood it. And certainly, as of 2 or 3 years ago, I was thinking of DNA, like I was becoming versed in DNA and trying to learn DNA, and the Alan Keels and the, you know, Heather Ericks of the world, and trying to wrap my head around the science. And last year, about this time, or maybe even a little before, I hear about this lady, Tiffany Roy, who's challenged the Barrett Sheriff's Office Crime Lab on their principles of analysis of DNA. And you know, we as lawyers, you walk around the courthouse, that's how you learn what's going on, and you're hearing, yeah, and they're ASCLD's doing an investigation. So you say, hey, what's going on? They say, oh, it's a bunch of, you know, I'm hearing it's a bunch of nonsense. It ain't gonna work. So, okay. I'm working on this case, and I'm doing DNA. I'm up to my knees in DNA in this case. Now I'm paying attention. And then lo and behold, July 18th, which is what you have in evidence as, I think, Art 16, July 18th, ASCLD rules, guess what? Ms. Roy's correct. Not only is she correct, but the Broward Sheriff's Office Crime Lab has to shut down their analysis of complex mixtures. Well, you know, that was kind of like a bombshell to a defense lawyer. I mean, clearly, I'm thinking, what about, this is a bunch of nonsense. So as quick as I could, I start to get up to speed as I can, and I hire Ms. Roy. And I take Singelis' depot in October. You heard about it when I called him. And I asked Singelis, so is that true? This is all a result of her? I'm asking him now, let me make sure I'm on firm ground here before I walk into a courtroom and start arguing this. Yeah. But really? And you're not going to be able to do this for a long time because now you have to get internally validated? Oh no, you heard it. We're going to do it tomorrow. So really? Oh, as soon as next week we're going to be doing STR Mix. Oh no, we can do it. So I was surprised, because I haven't talked to him since when he took the stand. I assumed they were up and running. I say to him, so you do an STR Mix? No. How come? Can't do it yet. Really? So, October, you're going to do it any day now? And here we are 6 months later, and you're still not prepared because your internal validations are that difficult to establish that your people know how to use the probabilistic genotyping software? Yeah. So not only is Ms. Roy right, but she's right about the fact that internal validation is not something you do overnight. And like she said, I could talk to John Buckleton for an hour and understand how it works because I'm familiar with other STR or probabilistic genotyping software. But then they challenge her, did you run the sample? She goes, no, I can't. I have to internally validate it to do that. And that would take months and months to do. So no, I've never internally validated an LR mix studio because I don't have the time. I can't do it. But what does that say about Ms. Roy in terms of general acceptance in the scientific community for the court to decide if she's a valid expert? Well, what it says is the people who are charged with giving Broward Sheriff's Office Crime Lab permission to get federal funding in the United States of America and to operate as a crime lab, those experts, and then the experts they hired, like Robin Cotton, who I know for 30 years, 35 years from Orchid Cellmark, one of the leading DNA experts as long as I've been doing this. Brilliant lady who's now running Boston, I think, Boston University, I don't know, something in New England in terms of DNA statistics and DNA analysis. But those experts ASCLD hired and reviewed this matter for ASCLD. All the experts were in agreement. Ms. Roy was correct. So the state got up here and said to you, where's the record evidence in this case that they were looking at the standards, at the known standards? There's no record evidence of them looking at the known standards, which we alleged in our motion. Really? Well, how about taking a look at allegation 1 in defense 15? This is the June 29th letter from ASCLD to Broward Sheriff's Office Crime Lab, Ms. Carter Pereira and Ms. Boardman.
What year?
June 29th, 2016. What did I say?
You didn't.
I'm sorry.
Just all I said was June 16th.
I'm sorry. June 29th, 2016. And it says, I'm sorry. As you're aware, a panel of 3 accreditation council members was appointed to reconsider the decision made by ASCLD as follows. Allegation 1. Inappropriate consideration of submitted known reference samples to determine loci that will be selected for statistical calculation purposes. And if you go through the rest of these opinions that were introduced into evidence, and ultimately to the July 18, 2016 memo that was written to Ms. Roy, because Mr. Singelis kept saying, no, they're still on appeal and this thing isn't finished. July 18, 2016, ASCLD writes her, Dear Ms. Roy, I'm writing to inform you our investigation and resolution of the complaint you filed with ASCLD. The board concluded the following conclusion. There was sufficient objective evidence to sustain the allegation 1. The board directed laboratory management to take appropriate corrective action to resolve the nonconformity.
No.
The board directed.
Take appropriate?
The board directed that laboratory management would take appropriate corrective action to resolve the nonconformity. So what you have here is them confirming that their use of the samples and the analysis of the reference samples and the standards was inappropriate. And she told you that her complaint was based on the fact that BSO was doing the very same thing that she believes McElfresh and Tracy are doing. That is, they're looking at the standard too early in the equation. And she was sustained by ASCLD, and I'll get to where it happens in this case, because so just with that as a backdrop, though, in terms of who has been able to demonstrate that there is general acceptance in the scientific community of at least their allegations and their representations and their opinions in this case, Ms. Roy has been generally accepted by the very people against whom this case is being brought, the experts that control those people at least. So, looking at this case, so Martin Tracy was the first statistician in this case. That is, when you go back in Forbes, at least in our case, the evidence or the witnesses submitted by the state, Martin Tracy was submitted as the population geneticist probably, I don't know, 8 to 10 years ago. His name was provided for us. And he was the sole statistician, never heard of Kevin McElfresh. And I submit to you, we never would have heard of Kevin McElfresh had it not been for Martin Tracy getting in trouble with FIU. Because when his problems happen at FIU, and I think the state, I mean, I can't say why, but probably the state, you know, acting rationally said, this guy may be in trouble and his credibility may be attacked and we may need another expert. So we need to get another statistician on board in case Dr. Tracy becomes unavailable. So who do they pick? Well, they pick Kevin McElfresh, second expert, because number one, you know, Dr. Tracy may be a liability, but number two, why? Because he's already done the work. Remember, Kevin McElfresh, according to Dr. Tracy and Dr. McElfresh, said we reviewed each other's work in this case, continually, did every time. And there was that report, the technical review that Dr. McElfresh prepared, saying that he completed a review of the work done in calculations and conclusions by Martin Tracy, goes through all the evidence, and he says, I concur with Dr. Tracy's conclusions and calculations. And that's what we asked him when he was on the stand. Yeah, I concurred with everything Tracy did. You reviewed Tracy's work? Yes. And he technically reviewed your work? Yes. And just to segue for a moment to yesterday, because I found that really rather compelling, was yesterday, when Dr. McElfresh gets up here looking at RC1 and goes through that little analysis for Mr. Williams and takes out his report on RC1 and goes to D3, and in the analysis part, when, again, remember, he says, oh, I'm not used to doing it in a courtroom in lights. No, he's just doing it on the fly, but this is a guy who's been doing it for 30 years. Knows this like the back of his hand. Look at an electropharogram. He should be able to do that in his sleep. Not us, but him. Right? So what does he do? He goes through Mr. Williams, loci by loci, goes to D3, looks at the two alleles, very low, one's under 50 RFUs, and I would discount. So you know because of what explosion happened. Ms. Roy and I are sitting there looking at each other going, whoa. I wouldn't use them in the calculation. Whoa. Because he did, and we know he did. And we know he used the wrong numbers too. So he goes on, and he finishes, and believe me, yesterday, that was a lawyer's dream. Because Mr. Williams turns to him and says, okay, and what was your calculation? And then he picks up his report and goes, I said 4. Did I say 5? I said, And when he got stuck there, that's why I jumped up, whoa, 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 don't let him weasel out of this. And then whatever happened, he goes, yeah, I did say 5, and I had a 17. Go, and what's Mr. Forbes? A 15-17. Oh, not only is there a typographical, but you got to see what his real thought was on that electropharogram. I submit to you, you got to see scientifically when he does it the right way, and he doesn't look at the standard first, you got to see what his opinion is. D3's worthless. At least for that purpose, for that experiment, you got to see what McElfresh would do with that electropharogram when he's not sitting down and planning out how to help the state. Because remember, the one that he made the mistake on is the one where he had all the time in the world to examine it and check it. But the reason I went to it just now is not just for that, but for the fact I then turned to him and say, you know, didn't you say Dr. Tracy technically reviewed everything you did? Yeah. No. So did Dr. Tracy technically review that document? No. What do you mean? I thought he reviewed everything. The only thing I didn't submit him is this one I made a mistake in. You know, isn't that, I said to him, isn't that a statistical anomaly? Isn't that like hard to believe? I just want you to think, Judge, for a moment. If there was a defendant on the stand charged with murder, and let's say he did something that he had previously testified, I do this every day the same way, every day the same way, and then lo and behold, the murder, the circumstantial evidence is, well, if you did it the same way, that's why we think it's you, because that's how it was done in this case. And then he got up on the stand and said, the day of the murder, I didn't do it that way. The state would turn to him and go, terrific! I'm going to get to turn to the jury and go, isn't that amazing? The one day the murder happens and it would look like it's him, that's the day he didn't do it. Yeah. Now listen, I'm no clairvoyant, and I don't know what's going on in Tracy's head, and I'm not here to be able to tell you how in the world he's able to tell us that. But I don't think you should suspend your common sense. Because Tracy is now, I'm sorry, Dr. McElfresh is now the Martin Tracy of Broward County. He has 173 cases that Dr. Tracy had. And as he testified, his FIU is in whatever, it's in limbo, I don't know what's going on. We went through that with him. Is he getting paid? And yeah, I'm going to get paid, whatever. But this is his money train. This work now is his money train. And if he loses this motion, he may substantially be affected financially. And I don't wish that on the man. I don't hope that that's what happens when he loses his financial input. But you have to be able to factor that in. You as the judge have to say, why would this man misrepresent things to me as a scientist in order to have his conclusions be found to be acceptable and be able to testify? Because if they're not, I submit to the court, it could have a financial impact on him. And just think, how is it that they, I mean, I know the state picked him, but maybe because he reviewed things, but when you want to think about who they could have picked to confirm now that Dr. Tracy's done everything right, they picked Kevin McElfresh, who was a student of Martin Tracy at FIU. So they pick an individual, I mean, doesn't that also have to suggest to the court that maybe his objectivity is not the best in terms of criticizing Dr. Martin Tracy? Because the case law, like we said, talks about not just independent scientific review, but empirical review. And I think that's in Ramirez, in the Ramirez case. It's in my memo of law. Yeah, it's in the Ramirez case at 849. They say, we conclude the state has failed to show by preponderance of the evidence that Clark's procedure is generally accepted by scientists active in the field to which the evidence belongs. In applying the Frye criteria, general scientific recognition requires the testimony of impartial experts or scientists. It is this independent and impartial proof of general scientific acceptability that provides the necessary Frye foundation. Well, I would submit to the court that Dr. McElfresh coming in here and saying, Dr. Tracy did everything correct and I'm doing the same thing, is hardly empirical, objective, independent review of Dr. Tracy's work. So then, what I'd like to do is go through the 4 points that are in my motion. And the 4 points, the first one is that the LR Mix Studio was not validated correctly by Drs. McElfresh and Tracy. First of all, Dr. Tracy testified he validated it by taking 5 times 5 and getting 25. Dr. McElfresh did something akin, but he plugged in some DNA statistics. But that's not all, like you've heard from the experts, Ms. Roy, Dr. Gill, but even from McElfresh himself. He says internally what the LR Mix does is it not only acts as a, he says, I just use it as a calculator, but while using it as a calculator, it performs a number of other functions. It inserts, or it attaches the database to the calculations, according to him. And he also, it does some other computations that he would have to do by hand. So when you hear that, when you hear what is going on with this, and you say, did you internally validate it? He says, I don't have to internally validate it because I'm able to tell it's working correctly because it multiplies 5 times 5 and gets 25. But the fact is, without internal validation, true internal validation, just like was deemed in the Hillary case I gave you, and attached to my motion, if you want, I mean, take a look at Exhibit A of what internal validation looks like. I attached Exhibit A to the motion, which is the Swig-Dam guidelines for internal validation of genotype software. It's 3 3 or 4 page just chapter on internal validation, like Ms. Roy testified, it has to have continuous analysis by going over various computations, calculations, being checked over scientifically. So then what we do in an effort to, I know Ms. Roy is going to be challenged on that, we go to Dr. Gill and we give him what's going on here. Ms. Roy sends the emails. The state put the emails in evidence. You have them. They say there's no evidence of anything about calculations not being, use as a calculator not being correct. And that's that first email we talked about yesterday, where he says, you're right, you cannot use LR-Mix or any probabilistic software in the way that is described. There is nothing published that would approve the practice, and it is important for laboratories to follow national guidance to internally validate software before use.
It's important for laboratories to follow.
It is important for laboratories to follow national guidance to internally validate software before use. And she talked about the fact that he was using it as a calculator. But more importantly, when you look at the report of Gill, of Dr. Gill, if you go to page 2 of his report, the use of probabilistic software to calculate likelihood ratios. And again, our argument is not he can't do calculations on likelihood ratios. He could do them by hand all day long if he wants. The problem is for him, he can't anymore. He's that old school guy that does them with a calculator. And like he said, remember Dr. Tracy said to him, really, you didn't save your calculations, why not? He says, well, Judge Holmes one day made me do that. See what happened? He says, well, it took me days to go back and do one calculation. So yeah, you can understand why these older scientists need something to help them. The problem is they don't have 25,000 for real genotyping software, so they get the free one online that's free to the public, and on top of that, they don't have the ability or the knowledge or the training. They weren't trained, they admitted, never been trained at all in it. I read the manual, and I just used it as a calculator and zeroed out all the probabilities of drop in and drop out. And I'll get to that later. But here, Gill says, in recent years, the use of probabilistic software to interpret complex mixtures has become increasingly common. And he cites, the STR-Mix, the other ones in the US and LR-Mix in Europe. These software carry out complex calculations that are impossible to do by hand. In order to use software correctly, it is important the individuals are properly trained, not only in its use, but in the theory of likelihood ratio and its application. The matter of validation is governed by local requirements of the jurisdiction. And you just heard about validation as it relates to ASCLAD, BSO Lab, Ms. Roy testified to internal validation by experts of probabilistic genotyping software. So this is Dr. Gill commenting on our case about the internal validation, saying that's not how it's supposed to be used. So like Ms. Roy said, I called John Buckleton, I called a couple of experts, they say it doesn't sound right, but you should go to the developer. So she goes to the developer. He renders this opinion. What does the state of Florida do? Do they say, oh, maybe she didn't give, they're arguing you, oh, she may have asked the wrong question. May have. Why didn't they go to Dr. Gill then? I mean, nothing prevented them from doing the same thing Ms. Roy did. Go to Dr. Gill and say, let me straighten out the question for you. They did. Why did they go to another expert who is versed in LR-Mix software? They did. How about getting any other expert to come in this courtroom and say, I have tried to do what they're doing and I can do it, even though in Brim and in Ramirez it says, it's not a nose count. How about trying a nose count? How about giving you one nose to count? Besides McElfresh and Tracy. Remember what they said. I asked them, do you know anyone else in the United States of America using LR-Mix? No. Do you know anybody who's ever used it as a calculator? No. Do you know any literature that suggests you can use it as a calculator? No. Well, where do you come up with that idea? You say, well, it doesn't say you can't use it as a calculator. Well, you know, when you buy a chainsaw, it doesn't say you can't use it for surgery. But you probably wouldn't. You know, it's just absurd that that's their logic. That that's what this scientist, smart man, well-educated, is going to sell to the court. Because it doesn't say I shouldn't. Gil told you, I mean, everyone's told you, it's a sophisticated program that takes months and months and months to validate. And I can shortcut that by zeroing out probability. And then I guess what the state suggested here is that Miss Roy is so smart that she can outsmart Gil and cause him to listen to her argument and join in, as opposed to figure out if she's disingenuously asking these questions or somehow misrepresenting to Dr. Gil what this is really about, that Dr. Gil can't figure that out. You know, that's just absolutely wrong. So really, at this point, the record is completely unrebutted by the state that they've used the LRMIC software without validation, other than the expert's own bald assertion that he's doing it correctly, which is exactly what, I think it was Ramirez or Brin said you can't do. The court can't. The court, the gatekeeper of the TRI standard, can't just take the bald assertion of the expert we're challenging as the only proof that he's doing it correctly. So now let's go to the argument 2. Argument 2 of the motion is the LRMIC was used improperly by McElfresh and Tracy when generating statistics. And what that deals with is the zeroing out the probabilities of drop-in and drop-out. So there's no question, Dr. Gil agreed that that's how it was designed. Ms. Roy testified that's the whole purpose of probabilistic genotyping software. Mr. Singelis, the technical leader for the DNA lab for Barrett Sharp's Office Crime Lab, tells you the very same thing. And all three of them agree. Why is this? Because you can't do this the old way anymore. Because these complex mixtures have so little DNA. And that's the point. This PCR technique of gathering, you know, it's gathering DNA that could be like the size of a period on a page, and then multiplying it, artificially multiplying it, to get it to be large enough to then have samples that you can run through the probabilistic, run through the machinery, like the 310 or the 3500 or whatever it is, to come up with some analysis of the DNA. And because of that, because of the way that that happens, the ability to then decide how much value is in this minuscule amount of DNA that you wind up with is something that the scientists really just have trouble doing now. Like, is it usable? Is it not usable? And for that reason, they all agreed. Singelis, Ms. Roy, Dr. Gil, anyone you ask that has contact with that, yeah, we need those. That's what we need this probabilistic genotype software for. Can't do the computation by hand anymore. Can't do all the decision on drop-in and drop-out. It's so difficult. It's so subjective, if you will, that that's where it leads to terribly misleading statistics to a jury. And you as a gatekeeper, you're the person that has to decide, does the jury get to see it? See, the state wants to draw this back to like two experts arguing about grease and trace evidence. No. It's not like, oh, two experts let the jury decide. No. You first got to decide, is it scientific what he's doing? And what he's doing has nothing to do with trace evidence. What he's doing is something that only in the last 10 years have scientists understood it. Judge, quite honestly, you don't understand it and I don't understand it. I mean, honestly, none of us understand it. I can parrot back the questions to her, but I need them put in my head the night before. But if I was going to sit down now and try to tell you or draw out what genotype software does, I have no clue. None of us do. That's why you really have to rely on the scientists. So who has the state given you to rely on? McElfresh and Tracy. They stand alone. And the issue about can't zero out the probabilities, Dr. Gill talked right to that. Here, on page 5 of Dr. Gill's report, top of page 5. The missing alleles under the prosecution proposition are said to have dropped out, where the definition of a dropped out allele is one that is below the validated analytical threshold. A probabilistic software, such as LRMix, is able to take account of allelic dropout in the calculation of the likelihood ratio. In this case, a probabilistic software, such as LRMix, is able to take account of allele dropout in the calculation of the likelihood ratio. In this case, the dropout probability, as used in the calculations I have seen, cannot be zero. And that's when he is analyzing JT 37.1. as it was submitted by Broward Sheriff's Office lab. So Dr. Gill agrees with Ms. Roy, you can't zero out those probabilities for drop-in and drop-out. You heard Dr. McInfresh yesterday. We all heard Dr. McInfresh yesterday. What did he say? He said, I can do that and determine if there's dropout at these other loci where there may be dropout or there may not. And only I can determine there is no dropout going on there, because when I determine that, I can zero it out because I know there's no dropout, whereas the software will put in a 10% probability maybe there's dropout, and therefore the number will get higher. And I'm really here to help the defense. But on top of that, I asked him, so you're better at this than the genotype software? And he had the audacity to tell you yes. Read his testimony yesterday. When you get his testimony from yesterday, he suggested to the court, yeah, like I said, you know, the state said he's a renowned expert. Dr. Gill is a renowned expert. Dr. McInfresh wouldn't say that. Is he a renowned expert? He's a developer of software. Is he a renowned expert? He's a DNA analyst. Is he a renowned expert? Is he a brilliant guy? He's an analyst. He won't agree at all. Just his game on the stand is to be very smart and very evasive, and he did a marvelous job at it. I'll grant him that he's hard to pin down as a cross-examination on an area that he's got the advantage, he knows the language, he knows the lingo. Very difficult to pin down. But at some point, your job, I submit, becomes a little easier when he can't give you a straight answer other than, I'm right, trust me, the genotype software, no one needs it. I don't need it. We don't really need it. So the misuse of this program by zeroing out probability is something we raised. And again, if the state thought for a moment that that's not right, and there's experts out there that could do this, that use LRMix, I mean, certainly, if I can find somebody, the state has the resources that I don't have, as we know. I mean, they have unending resources. They could find an expert that uses LRMix Studio and have them come in and tell you a single nose to count for you there. That you can zero out the probability as an expert on the LRMix Studio when you use it, and just use it as a calculator and it'll work fine. Nobody. That's not what satisfies the Frye standard. Not Mr. Raff getting up here and go, oh, he's been doing likelihood ratios for 30 years. He has. Not this way, though. Like he said, I got the LRMix a year and a half ago. So he's only been doing this for a year and a half. And I'm only challenging on what he did in this case, which was 6 months ago. In 2016, he generated his report. So the third argument is they look at the standard first. Now the state again says there's no record evidence in this case that they look at the standard first. Really? we've got, remember Dr. Tracy on the stand. So on the stand, I challenged him with his deposition. This is his deposition of February 20th, 2017. Because on the stand, he tried to say to you, I never look at the standard first. I always do look at the Ingraham first and all the data, and then I decide what's valuable and what isn't valuable, and then I look at the standard. I brought him back to page 16. Question. Okay, well, as I understand it, you just told us, though, that you did it reversed in this case. First, you looked at the conclusions of who they thought were the major profiles or not, and then look at the electropherograms, correct? Answer. That's correct. In order to identify the items of evidence that I needed to do, I needed to know which ones were mixtures, so I looked at the report in order to say you need to do a likelihood ratio on this mixture.
So,
Did you get that? Sorry. But in his deposition, he said that. And then when we told him, so you're looking at the standards first, he goes, oh, no, I couldn't have done that. I must not have done that because, I shouldn't be doing that. Well, really, you're the expert. How could those words ever come out of your mouth if you know scientifically that's not what you're supposed to do? But he says, yeah, I said to him, you just said you did it reverse. Did you do it that way? Yeah, that's correct. I looked at the standards in order to determine what the mixtures are and whether the major profiles are there. So Dr. Tracy says, yeah, I was looking at standards first. That's record evidence in this case. And Dr. McElfresh says, I do everything just like Dr. Tracy. I confirm all of his results. So there's record evidence of Dr. Tracy saying that he looks at standards first. And there is some record evidence of Martin Tracy doing exactly that. But also, what did we come up with in the middle of this hearing? They say there's no record evidence of this. What, 13? 13. Yeah. Defense 13, Forbes 13 in evidence. I guess Mr. Raff forgot about this. No record evidence of him seeing E-grams after he made his conclusions. The email from Martin Tracy to Adriana Alcalde, who was a homicide prosecutor, as we know, on December 30th, 2014. Please ask George Duncan to have Kurt send me the electropherograms so we can head off the, quote, you just rely on Kurt Rhodes' lab work, end quote, argument. And then a responding email from George Duncan, see emails to Uncle Marty and the state attorney's office. And the report, which is attached as defense 12 in this case, which is state of Florida, I'm sorry. Which is, no, it's all in this exhibit. State of Florida versus Luke Chamberlain. His report was drafted on May 24th, 2014. So his report is drafted identifying majors, minors, and his conclusions. And in December of 2014, like 6-7 months later, he's writing asking for the electropherogram so I can head off this argument that we know they're going to make, that I didn't look at the electropherograms first. Well, I don't have many better smoking guns than that, Judge. That's Dr. And when I confronted him and I said, what do you say to that? He says, oh, I was just trying to get the electropherograms to make sure, or some mumbo jumbo. That's just absolutely That's just absolutely wrong. There's record evidence of him doing it, and there's no reason to think that if, I mean, again, he and Tracy, like they say, they work hand in hand. They work together on this case, together. The first time they ever used LR Mix Studio was together. The first time they ever used it was together. The first time they tried it, the two of them tried it together. And everybody peer-reviewed, I mean, each of them peer-reviewed each other's work in the case. They worked hand in hand. So yeah, I couldn't get McElfresh to admit it. And I mean, listen, I got nothing against Martin Tracy the person. It's not like Martin Tracy the person. I kind of feel sorry for the man. Because maybe he is, seems to me he's slightly the older one, and maybe he's just a little less cognizant of, you know, what he should and shouldn't say. I don't know. But he certainly let that slip in depot, and that's a hammer for him. And that's bad for McElfresh. Because we all know, and McElfresh knows it now, if he ever admits to doing that, gets caught doing that, in this day and age of genotyping software and how you're supposed to do things, in light of ASCLAD's coming down on the BSO lab for doing the very same thing, he's out of business. And if he's been doing it before, he obviously can't admit to it now. So why would there be a reason? There's a good reason why he wouldn't be admitted to that. And then the fourth question in our motion, the last question in our motion, is the additional profile interpretation and statistical calculations by Tracy and McElfresh. They have insufficient training in, and it's not scientifically reliable. And the reason that's important, Judge, is because they told you they have no training. They told you they have nobody telling them what to do on this. And we don't have to comport ourselves to ASCLAD, nor do we have to comport ourselves to SWIG. We try to. What does that mean? You know, we all have guiding bodies. Lawyers do, judges do. Like Ms. Roy said, I joined the American Criminalistics of Forensics. Everybody can join some organization that oversees continuing education. These fellows don't have to get any continuing education. They don't have to prove they're keeping up with the science. They have nobody to answer to. And you and I both know that, you know, I mean, if I didn't have to go to CLE, I'm a pretty tired old guy. Maybe I would like to skip a class or two, but I don't because of my bar license to get renewed. These guys don't do it by their own admission. The last time McElfresh published anything was about 15, 16 years ago. And that's how these cases are telling you how he gets real empirical review, is by publishing papers for other scientists. So if he's saying, I'm using LRMX as a calculator, publish it. Guess what? Publish it. It's something experts do every day. Publish that. Say, here's what I'm doing. How about anywhere in the world? We got the internet now. Anywhere in the world, someone take what I'm doing, examine it, and come back and tell us, is that acceptable? Am I doing it correctly? Do you agree with me? What has the state of Florida marched into this courtroom and given you, in one instance of one expert saying to you, they're doing this correctly? Judge, the case law suggested, their own testimony suggested. And what I'm asking the court to do is not throw out all the DNA in this case. Unfortunately, what I think the court has to do, acting as the gatekeeper of case law demands and requires, is you have to decide if what they're doing is scientifically reliable. And if what they're doing on complex mixtures only, not the single source, it doesn't mean they're unemployed. I mean, yeah, they can testify all they want about random match probabilities on single source or any number of other computations. But when it comes to complex mixtures of such low profiles, and that's really what it is when it's very small, low profiles, not the one where there's major profiles and everyone agrees, there's no complaint. It's those instances like RC1A where Alan Keel does the very same thing. Mr. Satz catches them and just feeds them things and he says, it looks like Bernard Forbes, and then he goes back and says, you know, on the fly there, I sort of messed up, and I'm here to tell you, I messed up. I shouldn't have said that. It's worthless data. Well, so McElfresh can say that, but Mr. Keough, that's, how disingenuous is that? And I tried to ask Tracy, do you accord him that courtesy? No, he couldn't say it. He couldn't even say that. Yeah, he was in the same box I'm just claiming to be in. Tells you how honest Dr. McElfresh is. So what I'm asking the court to do is grant the motion in the limited context in which it was drafted, in the limited context in which we put the evidence on in this case, and in the limited context of what we proved. They are not reliable in statistical analysis involving genotype software of complex mixtures of low value.
Thank you, Mr. Moldoff. Why don't we take a quick break and then Mr. Aronson?
Yes,
Judge, I got to leave. My nephew's graduating.
congratulations.
Thank you.
Congratulations.
Thank you. Mr. Rath's going to be here.
And Mr. Marcus just walked out as well.
I could walk out on better, let me tell you.
It had nothing to do with you.
Yeah.
Let's just bring it.
You're leaving rapid.
Mr. Moldoff just got done saying. Mr. Moldoff ended with what he is asking the court to do, which is in the limited circumstances to rule basically that the procedures done by Drs. McElfresh and Tracy as to low-level DNA should be excluded, or the process should be excluded, and therefore the evidence should be excluded. I disagree with that because it is the process that they use that is defective. So whether they're using it for high levels of DNA or low levels of DNA does not matter. It is the process. And you know, the analogy is that even a stop clock is right twice a day. They may have been right in something that they have done with mixtures, complex mixtures. But that is irrelevant because it's the process that they use is fatally flawed in all aspects. And so therefore any evidence dealing with the complex mixtures, namely likelihood ratio, should be suppressed, should be not admissible, whatever the proper term is. So that's why I disagree with Mr. Moldoff. It's not just in low level, it's anything they did with it because it's the same process.
And Judge, I just want to remind the court, I have adopted Mr. Ingram's motion as it relates to their issue that they're about to argue with.
And Mr. Williams, you adopted both, correct?
Yes, I adopted everything.
Yep.
Now, Mr. Raff said something, and he said it in relationship to what Ms. Roy wrote to Dr. Gill. And he made the comment, how you tell a story has an impact on how someone assesses the information. And that's exactly what we're talking about with what Drs. McElfresh and Dr. Tracy did. As you heard from the witness stand, an electropherogram is a story. It tells you what's in the sample. Every line of it is information. And you heard that from the witness stand. So how you tell that story has an impact, as Mr. Rapp would say, on how someone assesses the information. And I'll get to that later, but more than what I want to bring out now about that is that if the story is being told incorrectly, if the story is being told prejudicially, then how somebody assesses that information is affected by how the story is told and whether they're being told it prejudicially.
Is that the philosophy, garbage in, garbage out?
That goes with computers, but I think it's more, and quite candidly, I'd love to say you're right on that, but I think it's more the slant that you put on it or what you tell somebody. It may not be garbage. And I'm not going to say that everything that you heard from the witness stand from Drs. Tracy and McElfresh is garbage. But if what they told, if the information and the story that they're telling is totally one-sided, is totally inaccurate, is totally inapropos, then what the person hears, they're going to get a slanted vision of what they've heard, and they're going to assess it through different colored glasses than real colored glasses. And so that's why I don't want to say garbage in, garbage out. I do believe there was a lot of garbage you've heard, But what I'm getting to is more the way it was presented and what the evidence is that presented. So I want to go to my motion dealing with motion to prohibit DNA testimony unless in a statistic or qualitative statement. Now, in that motion, I outlined too many pieces of evidence with what the reports told us. I don't want to go through each piece of evidence as to the terminology that we got. But when it came to using random match, we had terms, and certainly we had random match where we had terms that said it's a match to 1 in 180 billion, 1 in 4 quadrillion, whatever those numbers. I'm not attacking that. I'm attacking and saying that the jury cannot hear things when they have a random match, not eliminated, with no statistical number attached to it. Could not be excluded. Could contain. Cannot be eliminated. Can't eliminate. Those were terminologies that were used throughout the various reports that you had put into evidence without any statistical number whatsoever associated with that. And my position is, and I think the law backs me up, that alone is insufficient, and evidence and testimony of that must be excluded. Then we heard about likelihood ratio, and I only went through some of it. And I said I wasn't going to bore the court with all that I have in my motion, and my motion only had some compared to all the testimony you heard. But you heard things such as in the mixtures, 15 times more likely that it was 2 people, 3 people, 4 people, as opposed to a random 2, 3, or 4 people. And I think the court understands who I'm talking about. Mr. Forbes, Mr. Delancy, Mr. Ingraham, and Mr. Ingraham's son. You heard 6 times more likely that it was any number of those people. Present in a mixture but could not calculate a meaningful statistic. You heard 18,000 times more likely. You heard 86 times more likely. 5 million times more likely. 19,200,000 times more likely. 2 billion times more likely. Cannot be excluded. And yet none of them, not one of them had a statistical likelihood of inclusion as to any individual. Quite candidly, I don't care about Mr. Forbes, I don't care about Mr. Delancy, but it didn't have a statistical number as to those 2 people in those calculations. Certainly as to my client, Mr. Ingraham, and to his son, there was no individualized statistic. Dr. Tracy testified, and I was going to cite you to the record, but I now realize what my record is, because I only had my cross-examination printed out, and there are other people that have different ones. So I'm not going to tell you what page, because it would just confuse everybody, but he testified, each individual in a group has a different likelihood. So when you say that it is 2 billion times more likely or 17,000 times more likely that it is 2 people or 3 people or 4 people, you're saying nothing individual about that person, at least one of the people in it, because each one has their own likelihood. And that's according to Dr. Tracy. So since they have their own likelihood, what are we telling this person? What are we telling the jury? What are they hearing? They're hearing a number that's associated with all 4, but has no specificity as to the individual. And in fact, Dr. Tracy told us that. He testified, it tells us nothing about the individual. Dr. McElfresh and Dr. Tracy, and it was fun yesterday talking with Dr. Tracy on cross-examination. But the thing that I
don't think he testified yesterday.
Excuse me, Dr. McElfresh. And we had some good banter going back and forth. But the thing that was most important was the first question that I asked him. And that was the one that I really cared the most about. And he said, using likelihood ratio, the way he and Dr. Tracy used it, as far as 2, 3, or 4 people in a mixture, is the same as not excluded without a mathematical calculation of the level of inclusion. So what you have back now is, regardless of what the parameters are or the numbers are for all 4 people, as to the individual, what you get to from their own mouths is that it's the same as saying not excluded or included without a mathematical statistic as to the individual. I asked Dr. Tracy about whether he has to follow the ASCLD rule.
Dr. Tracy?
Yes.
Okay. I didn't know that we segued to Dr. Tracy.
Dr. Tracy. And I said, do you have to follow the ASCLD rule, which was, oh, I forgot the number of it. It's 5.101 and 5.10.3.5. And he said, no. He said, but I do have to follow Grimm versus State, the case that Mr. Moldoff just cited from. And he said, when you follow Grimm versus State, when you're talking about matches or can't be excluded, or just the term included, that you have to give a mathematical strength to it, meaning 1 in X amount. So therefore, from their own testimony, you put together the fact that they acknowledge that when you say the group as a whole, doesn't tell you anything about the individual, and really what you're saying is it's the same thing as can't be excluded. And then they tell you, and they acknowledge that they must file Grimm versus State, which says when you say it can't be excluded, you have to put a mathematical calculation on it. We got no mathematical calculation on that individual. And so based upon their own testimony, every piece of evidence in this case that does not have a mathematical certainty to the individual, and when I say certainty, I'm not talking about, and I shouldn't use the word certainty, a mathematical fixed number that they're willing to attribute to that individual, based upon their own testimony, must be excluded. So let's look at Grimm. I know you have there.
Yes.
And I'm not sure you and I have the exact same copy of it. So let me read from, if you have the copy there, right under the first page where it says Research Council, NRC 2.
On the first page?
That's why I'm, if I can approach and show the court.
Yeah.
You want mine?
That's one painting.
Research Council, NRC 2.
The one that I gave you?
I don't know where it came from.
That's not ours, this is ours.
No, I don't
It's
have
on the
that.
revised opinion,
Oh, because you said you had ours.
and then,
I thought I did.
you know, half a page.
Can I have this? Thank you.
Danny, you want another copy of Grimm?
You have mine?
Yeah, there's
You have the same one.
In
that
that
they're
folder
using.
titled Ingraham, there's one for you. That's the same as the one that Deborah had.
This one
Yeah.
out of your file.
Is it the same?
Well, because the one we provided to you in the blue folder will be the same one that Danny has in the red.
I'll find it. If you give me the other Grimm, I'll find it in the reader.
Make sure that's the revised.
Yeah. Oh, okay.
695.
695. Here we have one here. Yeah, it would be on your second page
This is the one I remember.
where it says, right under the words Research Council NRC 2. You see that in the right-hand column?
I'm sorry, Dan.
Now I have a different one.
Can I just, I'm going to walk up real quick and see where you are, so I know where I'm.
Second page.
And here it is, right here.
Got it.
Okay.
Nice paper.
We've apparently 3 different types of Grimm around.
Hey, Dan. Okay.
Okay.
Go into the room.
The insistence on quantitative estimation has been fueled by the observation in the 1992 report, page 74, that to say that 2 patterns match without providing any scientifically valid estimate, or at least an upper bound of the frequency with which such matches might occur by chance, is meaningless. Certainly a judge or a juror's untutored impression of how unusual a DNA profile is could be very wrong. This possibility militates in favor of going beyond a simple statement of a match to give the trier of fact some expert guidance upon its probative value. As noted above, however, there are a variety of procedures, qualitative as well as quantitative, that may accomplish this objective. Now let's talk about qualitative for a second. I asked Dr. Tracy, I believe it was, about qualitative. And I said, is qualitative statement such as everybody, nobody else on earth, or more people than have ever lived. And that he agreed that that's what a qualitative statement is. So if they said, we can't exclude Mr. Ingraham, and the likelihood that that his DNA is in that mixture is to the point where nobody else on earth that has ever lived would have that DNA. That would be a qualitative statement because it's telling some of us the strength of that association. We don't have anything like that in this case, and I don't really need to speak about qualitative statements anymore. So we're just dealing with a quantitative statement. What is the number? And Brim tells us that you have to have that, and they're talking about it with matches, that you have to have that, or it's meaningless. If you go to the next page, hopefully it's your next page, under analysis. Maybe 2 pages for each. Yes, it's a couple pages for sure, Chris, it's much bigger. In the middle of the analysis, it says, where you see the Southern Second is bolded right there, in the first paragraph.
Yeah.
It is important to recognize, though, that DNA testing is a 2-step process. The fact that a match is found is the first step of the DNA testing process may be meaningless without qualitative or quantitative estimates demonstrating the significance of the match. And that's what I've been saying the whole way through again, that you need the significance of the match or it's a meaningless statement. So now we go to that ASCLD rule. And it's in evidence, but I can give the court another one.
The evidence is all over there.
In fact, I have 2 if you'd like both. And let's just read the rule. Clearly and properly qualifying DNA associations in test reports. Each DNA association must clearly and properly qualified in a test report by either a statistic, that's what I've been saying, the numbers, or a qualitative statement. And as I said, I don't think we need to go into that because we never had one in this case. Each laboratory must clearly define the circumstances under which a statistic or a qualitative statement describing an association is to be utilized, including any key assumptions made during interpretation. A qualitative statement must provide sufficient information to clearly express the significance of the association. Note number one, association for multiple items or profiles. We had multiple profiles. May be qualified with a single statement if the statistics are identical or where applicable meet or exceed a laboratory-defined source of attribution or minimum threshold. Now you had Dr. Tracy, as I went over his testimony, he said specifically that everybody in the mixture is going to have a different likelihood. So we do not have the identical statistics, as note number 1 would talk about. So note number 1 is not going to apply as far as being able to make a broad statement. Note number 2, a qualitative statement not based on its statistical calculation should be limited to situations in which the presence of an individual's DNA on an item is reasonably expected. So they talked about the individual there. Laboratories should be aware that judicial decisions in many jurisdictions hold that the forensic DNA result must be accompanied by a statistic that qualifies the weight of the evidence in order for testimony regarding those results to be admissible in court. And that's what I've been saying the whole time through my questions. Accordingly, laboratory officials may wish to consult with legal authorities in their jurisdiction or the jurisdictions in which the testimony regarding the laboratory's DNA analysis is being offered to determine the potential applicability of this requirement.
What do you do when an individual isn't required to follow ASCLD?
You have BRIM. You have BRIM, and that is exactly what Dr. Tracy said he has to follow. And in fact, when I said you have to follow ASCLD, he said, no, I have to follow BRIM, but he said they come down to the same thing. So I'm just bringing this out that it's the scientific community that is bound by ASCLD has to follow it, but our state, through our Supreme Court, has realized the same significance needs to be in the associations.
Thank you.
So now we go to, and I must tell you, Mr. Raff filed a motion to have likelihood ratio and random match probability considered as, what was it, judicial notice. And through that, I started doing some research. So the first case he cited in his motion was McNichols. And again, I have a feeling that we are at different
Pages?
yes, because your print is much bigger than mine. And fortunately, I wish I had your print, not mine. I know you have it. Carolyn was so kind enough to print it out for you. Do you have another copy there?
I got it.
Okay.
And for those of us who have the larger copy version, could you just give us some head note guidance?
Yeah, I'm
on
going to
where-
try to
yeah.
find them. Okay.
Yeah.
Well, it'll be at page 136 of the opinion,
Okay.
using the little head notes, or the notes 136.
Oh, okay.
Okay, and you see the second paragraph down from the 136?
It's page 6 of the larger copy.
Thank you.
You're welcome.
Okay, at the end of the second paragraph, they say, the FBI did opine. You know what? We're going to skip over that. Let's go to the next page after that.
You know, I finally found the right page.
Okay. This is going to be, it's going to be 138 or 847 according to.
Oh, whoa, where are you going now? This is pages
I skipped the
later.
page, probably 2 pages for you.
Okay.
All right, 847?
Yes. Can you see where the 847?
I'm there.
Okay.
Right after
The next paragraph. Dr. Ware analyzed the data using a statistical measure known as likelihood ratio. That's exactly what we've had in this case. A likelihood ratio compares the probability that the defendant was a contributor to the sample with the probability that he was not a contributor to the sample.
What is this spelling? Where?
W-E-I-R. That's exactly, again, what I have been saying the entire time. That you have to have what the defendant's contribution is, not what the group's contribution, but this says the defendant. And it goes on, because it was unclear whether Takakisha's own, and common spelling for Takakisha. Because it was unclear whether Takakisha's own DNA was or was not in the evidence sample, Dr. Ware performed his calculations to cover both possibilities. Thus, he calculated one likelihood ratio on the assumption that Takakisha's DNA was not part of the sample, comparing the likelihood that the sample was comprised of the defendant's DNA and another unknown person's DNA, with the likelihood that the sample was comprised of the DNA of 2 unknown persons. Assuming that Takakisha's DNA was not part of the sample, it was 220 times more likely that the defendant was a contributor to the sample than he was not a contributor, again, for the individual person. Then Dr. Ware ran the calculation assuming that Takakisha was a contributor to the mixed sample, comparing the likelihood that the sample was comprised of the defendant's DNA and Takakisha's DNA, with the likelihood of the sample was comprised of the DNA of an unknown person and Takakisha's DNA. On that assumption, it was 37,000 times more likely that the defendant was a contributor to the sample than another unknown person was the contributor.
Now would you give the common spelling?
T-A-K-E-I-S-H-A.
Of course.
Common spelling.
I wasn't disagreeing.
Very, very simple. So through Commonwealth versus McNichols, I found a case that you have in front of you, and we do have the same print on this one, and this is Commonwealth versus Matai. Mattei, M-A-T-T-E-I. And let me give you the site. This is 920 Northeast 2nd, 845. And the other site for McNichols is 753 Northeast 2nd, 131. Now in Mattei, and we can go to the second page, actually the third page of the, no, it's the fourth page of what I gave you. And it says opinion Marshall C.J.
Yep.
Okay. And towards the bottom of the first long paragraph, we conclude how we reject the defendant's sufficiency of the evidence claim. We conclude, however, that expert testimony that DNA tests could not exclude the defendant as a potential source of the DNA found at the crime scene, absent testimony regarding statistical findings explaining the import of such a result, was likely to confuse and mislead the jury such that any probative value of the test result was substantially outweighed by the prejudicial effect. And that's what we have with the way the state's experts have done it. It is prejudicial. And Mr. Raff said it had a probative value. But the probative value of it is outweighed by the prejudicial effect of lumping 4 people together and say the 4 of their DNA in a mixture is 1 in 7 billion. The likelihood that you'd find somebody, other 4 people, random 4 people, is 1 in 7 billion. When you don't know that maybe Mr. Ingraham's DNA, the likelihood that you'd find Mr. Ingraham's DNA or somebody that matches Mr. Ingraham's DNA is 1 in 2, 1 in 1, 1 in 4. We do not know because of the way they did it. And therefore, the prejudicial effect to Mr. Ingraham is outweighed by any probative value. Now, the state said, well, we wanted to frame it that way for the 4 people. I'm not on trial against Mr. Delancy and Mr. Forbes. We have determined that we should have a joint trial. But my trial deals with the state versus Law&Crime. And it is prejudicial to Mr. Ingraham that a statistic that embodies 3 or 4 people is used against him when he is entitled to have a statistic used against him or for him that determines the association of his DNA in a mixture, irregardless or regardless of anybody else's DNA possibly in that mixture. And to lump them all together like that, the prejudicial effect certainly outweighs the probative value. Later on in that opinion, let me count the pages. I think it's the 6th page, page 7 it says on the bottom.
So it does.
Excuse me?
It says page 7.
Okay.
Oh, you even underlined it for me.
First underlining. The expert did not testify as to the probability that an individual randomly selected from the population would also not be excluded. So again, and I just took that out of context, but it's talking about the individual. And if you go down or further down, the last paragraph on the page, we have also held that in a criminal trial, we will not permit the admission of test results showing a DNA match to a positive result without telling the jury anything about the likelihood of that match occurring. So that goes again, that is certainly in accord with our state's written decision. The top of the next paragraph. We have explained our approach by suggesting that evidence of match based on correctly used testing systems is of little or no value without reliable evidence indicating the significance of the match. That is evidence to the probability of a random match of the victim or the defendant's DNA in the general population. Again, it's the defendant. It's not defendants. It's not a group of people. It's not suspects. It's to the defendant. Next paragraph. The same reasoning applies to evidence that a DNA test, although resulting in less than a complete match, and that's what we have here with less than complete matches,
could not exclude a particular individual as a potential contributor without reliable accompanying evidence as to the likelihood that that test could not exclude other individuals in a given population, the jury has no way to evaluate the meaning of the result. And I think that says exactly what we have been arguing here. There's no way the jury can understand the meaning of the results when you have a 4-person or a 3-person mixture and you just give the whole thing in a broad brush for all 4 of them, because it doesn't tell you about the defendant and it is meaningless as to that defendant. The next paragraph. Further, admitting evidence of a failure to exclude without accompanying evidence that properly interprets that result creates a greater risk of misleading the jury and unfairly prejudicing the defendant than admission of a match without accompanying statistics. So we started off with matches had to have accompanying statistics, and this case points out that this is even more misleading when you say that you can't exclude somebody and you don't give a statistic as to that individual. That becomes more misleading than the match of a person without an accompanying statistic. And again, that's exactly what you had in this case. Then if you go to page 8 of the opinion, top of the page, if the jury are not provided with a similar statistical evidence where the DNA test result is a non-exclusion, there is a real risk that the jurors will be misled into thinking that these DNA test results are similarly significant and that the non-exclusion evidence is similarly conclusive as to the match contributor's identity, when in fact the actual meaning of such results can vary substantially. Now they're talking in here where there's a match and then there's somebody else that can't be excluded. But it applies to the same thing when you have 4 people in a mixture. You're giving the prejudice that they're talking about there, that the numbers that you associate with the group, or in this situation with the known contributor, is going to spill over to the individual defendant. And here, exactly in our case, those astronomical numbers, or some numbers that weren't so astronomical as to the likelihood of 4 people being in a mixture, spills over to each individual defendant to their prejudice. Bottom of the page, the Commonwealth, bottom of that column, the Commonwealth's reliance on Commonwealth versus McNichols is similarly unavailing. The defendant's argument in McNichols was not as it is here, that the test results were unduly confusing and prejudicial without accompanying statistics. Rather, in McNichols, the defendant conceded that the test results yielded some reliable, relevant information, challenging only whether the test could be read to yield a more precise result. Then if you go later on in that paragraph, they still talk about in McNichols. In McNichols, we did not have occasion to consider whether the probative value of DNA non-exclusion testimony, again, non-exclusion, that's what we have, might be outweighed by the prejudicial possibility of jury confusion. As to that question, DNA test results are not the same as a descriptive information about a physical trait such as height, weight, and hair color described in McNichols' supper. Because jurors can readily observe physical traits within the general population, the jury is presumed to have a grasp of the frequency of these characteristics within the general population. DNA evidence is different because a juror is unable to observe a person's DNA. The juror has no idea of the frequency of a particular DNA profile. And it cites Peters versus State.
Which is in Alaska, too.
Excuse me?
That's in Alaska.
Sure.
Okay.
Well, and you're going to find the cases I'm relying on are from all different jurisdictions, because no matter what, Dr. McElfresh testified yesterday about if you do an LR the way he can do it. I and only the state has found one case in the state of Florida that talks about likelihood ratio the way they have done it. So I don't have a case to bring to you from the state of Florida because I don't think there is one that exists. The challenged expert testimony concerning the non-exclusion results should not have been admitted without accompanying statistical explanation of the meaning of non-exclusion. Then we have Garcia versus State, and I think this is going to get us to one where we have different sizes again. It's going to be on page, of their opinion, we're looking at page 1004 or page 84. It's number 26 if you found it on.
Almost.
Talks about NRC 2, number 26.
Got it.
And this is State versus Garcia, and that's going to be 3 Pacific 3rd, 999. Their quote there, talking about Dr. Ware's formulas satisfying fraud. And if you notice, that's the Dr. Ware we talked about in the last case, and I hate to use the word, but these cases seem pretty much all to be incestuous, that they all cite one another and go back and forth, and so you're going to see common facts of one case that are going to appear in another case. Although likelihood ratios are rarely introduced in criminal cases, that's the first thing they start off with, we believe that they are appropriate for explaining the significance of data and that existing statistical knowledge is sufficient to permit their computation. None of the LRs that have been devised for VNTRs, variable number tandem repeats, VNTRs, variable number tandem repeats, can be dismissed as clearly unreasonable or based upon principles not generally accepted in the statistical community. Therefore, legal doctrine suggests that LRs should be admissible unless they are so unintelligible that they provide no assistance to a jury or are so misleading as they are unduly prejudicial. And the numbers you have in this case are so misleading and they are unduly prejudicial. Then we go to State versus Bander. And this is a Washington State case, so we're getting around the country right now. We've been to Massachusetts, we've been to Arizona, and now we're in Washington. State versus
New York too. And New York too.
And New York too. And now this is 208 Pacific 3rd, 1242 in the State versus Bander. And the State versus Bander, and that's going to be at number 31.
B-A-N-D-E-R.
Common spelling. You can get Takakisha, you can get Bander.
With you.
The second statistical calculation that a forensic analyst may perform is an estimation of the likelihood ratio. An LR calculation measures the strength of evidence under alternative hypotheses about the source or sources of the DNA in the unknown sample. For instance, an LR calculation estimates how much more likely it is that the suspect is the source of the evidence than it is that the evidence originated from a randomly selected member of the population unrelated to the suspect. Well, here, unfortunately, we have relations also in our situation. Essentially, this calculation involves dividing the probability of one origin hypothesis that the suspects, and that's not plural suspects, it's possessive suspects, DNA is in the sample, by another origin hypothesis that the DNA is the sample came from someone else. And again, this case, like the other ones, limited to finding the suspect's DNA. Not multiple suspects, not multiple defendants, but the individual. Then we go to Delancy. And as I said, we're moving around the country because now we're in Indiana. And Delancy is D-E-L-O-N-E-Y versus State, 938 Northeast 2nd, 724.
Scott at least put paper clips.
Scott and I had a conversation about it.
Yeah, and just so we're clear, I was lectured politely by Mr. Aronson that one does not highlight and clip. The judge can read for himself. And then I see right after I get that lecture, he underlines when he hands stuff to you. So, okay.
These were the ones that were not supposed to go up there.
Guys,
Okay.
Which case?
where are we in this opinion?
Delaney, we're at head note 6. Delaney.
Gotcha.
The third approach, which requires accompanying statistical data for DNA evidence to be admissible, comports best with our existing...
Whoa.
Number 6. Should be on page 5.
Oh, I see. That was hidden. Yeah, now I understand where you are.
The third approach, which requires accompanying statistical data for DNA evidence to be admissible, comports best with our existing law regarding admissibility of evidence. For example, in Commonwealth versus Matai, and they cite that, the Massachusetts Supreme Court held that it was reversible error to admit expert testimony that the defendant could not be excluded as a potential source of DNA found at the crime scene unless there was accompanying testimony explaining the statistical significance of the non-exclusion. Going down to the end of that same paragraph. Therefore, DNA evidence that does not constitute a match or is not accompanied by statistical data regarding the probability of a defendant's contribution is a mixed sample, is not relevant. So they don't even, this court is saying it's not even relevant. Not that it's the prejudicial value outweighs any probative value of it. They're saying it doesn't even meet the relevance standard. In the instant case, Winters was unable to exclude Delaney as a contributor to the DNA profile on the hat, and she was unable to give any statistical analysis of the probability of a match. Therefore, her testimony could not assist the jury in understanding the evidence or make the existence of some fact more probable or less probable. Thus, the DNA evidence and Winters' testimony lacked relevancy and should not have been admitted at the time of trial. Moving around the country, we're now in Michigan. And we have Huff, and you do have a different one than I do, I think, on Huff. And it's Huff versus Davis, and it's cited as 2007 Westlaw 313576.
And you're taking us to where?
Excuse me?
And you're taking us to
I
where?
just took us to Michigan.
No, I know that.
Where in Michigan?
Where in Michigan?
Well, I am at what they would have as, there'll be a number 9. I'm at 2 paragraphs above the little number 9. I have it on page 7. You probably have it on like page 10 or 11 with your copy. You know what? This goes to a different part of the argument. I'll just skip over it right now. I'm going to skip over this one. This goes more to what Mr. Moldoff was arguing. But so we've left Michigan, and now we're traveling to New York again. So we're getting around this country, and we have People versus Lopez. 23 New York S 3D 820. And I'm not familiar with New York sites, so I don't know what that exactly means.
New York Supplement 2nd, I believe.
Thank you. And if you go to the opinion in the case by Ralph Fabrizio, common spelling. Fabrizio. Towards the middle of that, a little past the middle of it, in the first paragraph, they say, then using the forensic statistical tool FST, and I don't know what that is, we had no testimony. The criminalist formulated a likelihood ratio that the defendant was a contributor. The finding is approximately 828 million times more probable that the sample originated from the defendant and one unknown person than it originated from two unknown, unrelated persons. So again, that's dealing with the defendant.
But how many of these cases are co-defendant cases? I agree. I mean, if it's one defendant, they're always going to be dealing with the individual.
I did not do that analysis, to be honest.
Statistically or otherwise?
Statistically or otherwise. But on the last page of the opinion, not counting the parts where they have the footnotes that are the follow-it.
That is interesting. Last page.
Here, of course, the FST allows the criminalist to testify to more than a vague possibility. The likelihood ratio found that the defendant is 838 million times more likely to be a contributor to the mixture is relevant and has substantial weight. And that's what we've been saying. That's when the weight comes in, when it goes to the defendant. This may help answer your question, Your Honor. We're now going to People versus Collins. Staying in New York. I think we went from one borough to the other. I think we went from from Brooklyn to the Bronx.
Or the Bronx to
Brooklyn, right. People versus Collins, 15, New York, Supplement 3D 564.
Where?
And it's the third page of mine, and I think that's the same one as you have.
I'm on page 3, so take me to where we're going.
Yes,
we're going down to the FST software permits?
Yes.
It's underlined?
Yes. Through mathematical analysis, very importantly factoring in this probability of stochastic effect, the FST software permits an analyst to state a likelihood ratio. How much more likely or less likely a two-person or a three-person DNA mixture is if a suspect is a contributor than it would be if instead the suspect was not a contributor. So as to what you were just asking seconds ago, this is talking about a 2, 3, 4 person, whatever mixture, and it's specifically, they hone in on that the purpose of this is for the suspect, the individual, not for the mass or the conglomerate of the group. And now we're going to deal with one of my favorite movies, The Freshman, because we're going to the great state of Montana. And if you remember that movie, whenever he was announced, the freshman, he was always from a different state according to, what's the guy's name? Marlon Brando. So, from the great state of Montana. And it's 68 Pacific 3rd, 768. And this is Ayers. This is state of Montana versus Ayers. And I think you have the same copy as I do. So
you go in a second.
A-Y-E-R-S.
Tell me where we're going.
And we're on page 10.
Thanks. This one even has numbers.
And on the top of page 10, it says, to evaluate how strong that proposition was, it had to be compared to another explanation, such as the hypothesis that Phyllis and an unknown individual were contributors. Then we go over to page 12, the bottom of the first column. While we recognized in Weeks, with a citation, courts...
Whoa.
Page 12.
I'm on page 12.
The bottom of it on the left-hand side.
Where it says number 20?
There's a 49 right there.
I have a 20.
Okay. And we have a different page 12. Can you please go to where it's under head note 12 and then there's a 49?
Thank you.
While we recognize in Weeks, citing the Montana site, that courts must be mindful that the probative value of statistical probabilities evidence is not outweighed by unfair prejudicial effect. And again, they're just making the note in that that's something that you have to be cognizant of. And that gets us back to what we have is prejudicial effect in this case. We have one case that would say it's not relevant. We have other cases that would indicate that its prejudicial effect is outweighed by outweighs the probative value. We have all the cases talk about an individual. And you ask me how many are co-defendant cases, but it's not just whether the cases are co-defendant cases, it is the theory of the law. The theory of the law is that we have to have it for the individual, because without having the statistic on the individual, all we do is have prejudicial testimony that, as the cases say, the jury is not going to be able to decipher. They're not going to, when they hear a number of 2 billion, 130 million, that 3 people or 4 people are in a mixture, the cases tell you they're going to be unable to say, well, that may mean that Mr. Ingraham has really no part in it. They're acknowledging that jurors are unfamiliar with DNA. It's not something they're common with. And so even if I say to their expert, well, can you tell me what the statistical significance is of Mr. Ingraham? And they say, no, we didn't do that calculation. That doesn't leave me anyplace. That leaves me with prejudicial testimony. And the prejudice certainly outweighs any probative values. Now, the state, in their argument, gave you Mickens versus State. And that was 121 Southern 583. And in the last page of Mickens, and I don't know if you have it there or not, the last page of Mickens, in the middle of the paragraph in the left-hand column, it's one of the places where Mr. Raff did the boxing. It says, DNA was recovered from a cigarette butt found in the victim's car, and testimony was introduced that the DNA was of a type shared by the defendant. A type, the DNA that they were able to get out of is the same for both the defendant and the defendant's brother. And 12.2% of the African American population, 6% of the Caucasian population, and 4.8% of the Hispanic population. They were able to say that that DNA was the type that would come back one or either of the brothers to a mathematical inclusion. They didn't say as to both brothers combined. They both had the same DNA on it. We don't have that situation where we have all the defendants have the same DNA. We have a conglomerate of DNA on it. And because you have a conglomerate of DNA, you can't make this statement. At least in this case, they were able to say that obviously the limited amount of DNA, based upon what we know from what we've heard over the last weeks, it had to be one loci at most, because to get to those low numbers. And both the brothers had the same, obviously had the same DNA the same alleles at that loci, which is understandable because they have the same parents.
But the court let that in.
Right. Because they were able to give a statistical number, both brothers had the same DNA. It's the statistical number that allowed it to come in. And it was to that each defendant. Defendant A, the statistical chances that belongs to you is 12.8%. Brother B, the statistical that it's for you is 12.8%. Not a combined, the two of you together, what's the likelihood? They were able to, because of the nature of the DNA, give a number to each individual defendant. Now, Mr. Raff read from the Swigdan Interpretation Guideline for autosomal STR typing by forensic DNA testing laboratories. And that was one of the things he read from. And I want to read from the first page of it. I'll go to the middle of it. Depending on the hypothesis and assumptions made, different LRs will result. In these instances, multiple hypotheses and LRs may be necessary for the case file in order for the court to determine which propositions are most appropriate. And we didn't get that from Dr. McElfresh and Dr. Tracy. We didn't get multiple hypotheses. And the Swigdam rules are saying that in certain cases, and I submit to you, this is one of those cases when you're solving for 4 or 3 people, that it's incumbent on the person who is doing that, if you're following the Swigdam guidelines, it is incumbent upon them to have the multiple hypotheses so that you can determine which one, if any, is most appropriate. And the one that would be appropriate would be the multiple hypotheses that segregate the individual, Mr. Delancy, Mr. Forbes, Mr. Ingraham, or Mr. Ingraham's son. And it was incumbent upon them to give you those hypotheses according to Swigdam. And Mr. Rath read from this first page. And we did not have that in this case. We did not have these multiple hypotheses. Swigdam guidelines were not followed. On page 58, and this is 4B41 of the same document, an unrestricted LR is the LR calculated without consideration of the relative peak heights observed during interpretation. Now you remember when Mr. Rath and Dr. McElfresh did their little dance routine there, because, and I say with complimentary, because it was very good the way they obviously practiced their steps back and forth.
Actually, there was no practice.
It was obvious. And
It was a good dancer.
Naturals.
Anyhow, and it was pretty. But the bottom line of it was, Mr. Rath had the equation, if A and B are at peaks 300, whatever number he gave, and C and D are only at peaks 150, 170, whatever, what do I do? You know, what do you do? And he said, well, you know, you look for the common alleles, the whole thing. Well, what I'm getting to is that would be under this document what's called an unrestricted LR. And it says an unrestricted LR is the LR calculated without consideration of the relative peak heights observed during the interpretation. As such, the unrestricted LR may include genotypes in the statistics that have been excluded during the interpretation and comparison steps of the analysis. Well, Dr. Tracy and Dr. McElfresh did not include things that could have been excluded, that they excluded. But this says, as such, the unrestricted LR may include genotypes in the statistics that have been excluded during the interpretation and comparison steps of the analysis. So they left out one of the things that this guideline is telling you that you can do, which is you keep in those things. 4B5. The LR requires that the hypotheses be formulated based on relevant case information, such as case circumstances, individuals involved, evidence types, or source. These hypotheses may involve different assumptions and should be evaluated and documented in the case file. So they're expanding on what I said in the first part of that, which was they had to have different hypotheses instead of there just one hypothesis. (4B7). The calculation of the LR should incorporate peaks determined to be indistinguishable from stutter when the numerator of the LR would assume that the person of interest contribution, even if the person of interest DNA profile does not contain these alleles. Now that's the most important thing. In the numerator, there should have been alleles that were contained in there that even do not have the person or the suspects or the 4 people, whatever, their alleles in it. This is saying they should have been included. And that's why when I got over there with them, I said, based upon the way you do it, you're going to win all the time. The state's going to win all the time. You're cooking the books. Nothing is going to be higher than that one based upon the way you do it. But if you do it the right way, you're going to get numbers that are different than the one at top. And therefore, there's a chance that the number on the denominator is going to be greater, and therefore there will be a negative association. So I asked Dr. McElfresh, how many times have you come up with a negative association using your formula? And he said he didn't know. And I said, never. And he said, no, I've come up with it. I said, how many? I can't give you an answer. Give me a statistic, percentage. I can't do that. But this was the same man that was able to tell Mr. Raff that he remembers what he didn't read when it came time to talk about that he would have known that Dr. Gill wrote something if in fact Dr. Gill ever read it, and he doesn't remember ever reading something. Well, this is his own statistics. This is his own mathematics. He lives this stuff, and he couldn't, and he's a statistician, and he could not tell us a statistic, a range, 10%, 20%, 5%, 50% of the times when I do this, I get a negative association. And the reason is because the way he did it, which contravenes what Swigdam says you're supposed to do, and gives you, he's cooking the books, and you cannot get anything other than a positive association based upon the way they do it. And then they say, well, the reason for that may be because we are ferreting out already all the things that would exclude somebody. Swigdam tells you, you don't do that. You keep it in. And that's what STR Mix does. And that's what all the probabilistic genotyping software does. They keep it in. And the way they do it, they end up with a positive association all the time. They don't follow Swigdam. They make up their own rules as they go along. They peer review each other's work and say, I like what you do. I like what you do. And because they both like what each other does, and one taught the other person, all of a sudden they become experts. They are not experts. They're not even correct. Mr. Moldoff talked to us about that Casillas, it has to be generally accepted in the scientific community, what they do. I've gone through this book, and I cannot see one time that the equation that they use for multiple suspects ever used in this book that we have right here. They have
Swigdam?
Yes. They have not written treatises. They have not had peer-reviewed articles. They have done nothing to put out to the general scientific world what they do and get feedback saying, your work is groundbreaking. You guys are the geniuses of all geniuses. The work that you do is incompetent, and that you're cooking the books, and it's not fair to anybody that you're testifying against. We don't know. Well, it's not our burden. It's the state's burden to make sure Doctors Tracy and McElfresh and what they do meet scientific rigor, and it's scientifically accepted in the community. And I agree with what Mr. Moldoff said. Mr. Moldoff said, that them getting up there and saying, I've been doing this for 30 years, I've testified 100 times, and this is the great way of doing it. They don't have the ability under Ramirez to make bold assertions, and that's all they did. They made bold assertions. Ramirez says, you can't make bold assertions. You need other people to come in. You need, show us books, show us something. Let them bring in articles upon articles that say everything that they do, Dr. Gill does, Dr. So-and-so does, Dr. Everybody does. They didn't do that. They left you with, we say so, we are a closed-knit community of two, believe what we say, because we believe each other. And that's what you got. When you synthesize it, that's what you got. And Mr. Moldoff brought up the fact that they're the only ones in the United States to use LR mix as a computer. A calculator, excuse me. Now that may be proper. I don't think it was from what you heard. But the fact that they're the only ones that do it should cause this court to have incredible concern as to whether what they do is accepted in the scientific community. Because 2 out of 300 million people in the United States, and let's say there's only 200,000 people that do this, or 100,000, or 50,000, or 10,000 people that do what they do. 2 doing it is not accepted in the scientific community. In fact, it's unaccepted in the scientific community, and what they do is unacceptable. I want to just finish off by going back to what my motion was about. And what my motion about is fairness. My motion is about making sure that my client gets a fair trial. And the only way he gets a fair trial is by you following the cases from around the country that, number one, say that when you say excluded, can't be excluded, included, or matched, you need a statistical association. They all say that. Number two, you need to remember the testimony of Dr. McElfresh and Dr. Tracy, who both agree that when you say 4 people are more likely to have contributed to that DNA mixture than to 100,000 than random 4 people, the essence of that testimony, they acknowledged it, is that you're saying is that Mr. Ingraham, Mr. Forbes, Mr. Delancy, or Mr. Ingraham's son are included in the mixture without giving them a statistical number associated with them. That, you've learned from all this case law, is improper. So whether they dress it up, bundle it up, package it up in a nice little thing to say it's all 4 of them, when you synthesize it down, you get down to specifically, you're still saying, as to my client, Mr. Ingraham, that he cannot be excluded without giving him a statistical number associated with it, and that is inadmissible testimony, and I'm urging the court to rule that way. Thank you.
All right, well, Judge, may I make a comment?
I was just about to ask you if you had something you wanted to chime in
I want to...
before Mr. Raft gets his shot. Sure. We just took a break. Oh, you mean after Don?
I'm going to be very short. I want to demonstrate to you, I think, the items that are in evidence here to amplify what Mr. Aronson was just saying about that you need an individual statistic. And he was talking about a spillover effect, or a major spilling over onto the others. Here the others are either Mr. Forbes spilling over onto Mr. Delancy and Mr. Ingham, or vice versa. I went through the documents that are in evidence here. These gentlemen have a common allele at 7 of the loci. I mean 5 of the loci, 5 of the 15. So of course it's going to spill over. I mean, you go to Tho 1, they all have a 7. So if there's a 7 that shows up in the analysis, whose 7 is it? And of course it's going to be skewed because they all have a 7. And in 5 of the 15 loci, they all have a common allele. And in the Tho, the 7, that's 40%, according to Ms. Roy's chart, which is in evidence, 42% of the black population has that. So that's why you need an individual statistic, and that's why the prejudice of this is substantially outweighed by the probative value, because the figures are always going to be skewed to include these 3 in a group because they possess so many common alleles. And I just wanted to point that out, and you can draw this from the commonality of their alleles. You can draw it from Ms. Not only Mr. Keel's reports, because he outlines all the alleles, and also in Ms. Roy's statistical analysis that she did of random match. Again, Delancy's problem with this is the same problem that Mr. Aronson has with this, is this group hypothesis of this likelihood ratio. And to amplify with what the Fry test talks about, a student and a pupil, and that's what you've got. A student, a professor and a pupil. You've got Dr. Tracy, the professor, and Dr. McElfresh was his pupil. And those two people in the United States who were so joined at the hip, not only where they work, the cases they work on, that does not equal general acceptability in the scientific community. A group of 2 who are so interrelated that they might as well be partners, even though they're not, because they seem to always get into the same cases, and particularly now they're in the same cases in the Dr. Tracy's credibility question. I think whether you adopt the Fry standard and exclude it on that grounds, or whether you just choose to exclude it on the prejudice outweighs the probative value, that group hypothesis, those statistics should be excluded. That doesn't affect the major profile evidence in this case, which is probably the most important evidence that the state wants to get in. And when you lump these guys together in a group, that also plays into what's one of the counts in this case, a conspiracy. That lumps them in, that's subtle evidence that lumps them into a conspiracy without any individualization as to how they appear in that group. And I think it's a subtle way of saying this is trying to prove this is a conspiracy, that the DNA is all lumped together without there being any individualization as to or individual statistic as to that person's where that person's DNA falls on that particular item.
And a Lilly conspiracy.
Scott, do you have any objections going to Carolyn, Jeff, and
Oh, by the way, thank you, Mitch. As much as I hate to say it, it actually worked.
Oh, good. I can tell.
All right, let me just take a couple of things. There's a lot of things that I don't feel are necessary to have to repeat. You heard the evidence, you listened to the arguments already. Let me just highlight a couple of things, specifically as it relates to the law. One of the things that, and I'm going to take them in order, one of the things that Mr. Muldoon talked about was the Grimm case. And I agree it's a significant case. It's frequently cited dealing with the issue of DNA and making an analysis. And Mr. Muldoon's argument to you was, well, there's your proof. The Supreme Court of Florida says this requires a fly hearing. No. Please read that case. That case was about the fact that there was a specific challenge to a database, and that particular database had not been through a scientific challenge. And given the circumstances and changes in the NRC rules, there was a legitimate basis to remand for a hearing to deal with that issue. There's no case out there, nor would there ever be, from any court, suggesting that a given issue is always subject to a Fry challenge. The concept of science becoming generally accepted answers the question on its face. The Grimm case dealt specifically with something that was new and novel, and at that time, given that database, in 1996, they applied a Fry standard and they remanded it back. What's interesting about the Grimm case, among other things, it's got some great language in it, but I happen to notice just this one particular line. I want to know where to go, but I don't know what everybody's copies are. Mine is 14 pages long, so this would be page 9.
Whatever.
By analogy, the fact that we now have calculators does not make longhand arithmetic unreliable. If anything, calculators make such longhand work unnecessary. Necessity, though, is not a concern of Fry here. I noticed also that Mr. Moldoff talked about the Casillas case. And he quoted language from the Casillas case, which I believe you should have, a copy of which you should have.
I have all the cases that have been cited.
If you read the Casillas case, the issue that it was remanded back on is because what happened in that case is that the state did not demonstrate what's the method of calculation that you did. A scientist just came up and said, I did calculations. They never said it was random match probability or any other calculation. And so what the DCA remanded it back for was a hearing on what that calculation was. If you look at my judicial notice document, I cited Casillas. And I cited it because in a footnote, they added the thought that if the state can also demonstrate that the calculation that wasn't identified is random match, game over, since that's acceptable under Fry. Mr. Forbes argued about some New York cases. There's been citations to a number of cases out of New York. I'll limit my comments to this. They talk about probabilistic genotyping, which was not done in this case. But it is amusing, since you have them all up there, that the Hillary case and the Collins case, which talk about the use of, and there are two different programs. SDR Mix was one, and Mr. Aronson was making a reference to FST, which, by the way, is the Forensic Statistics Tool. And those two cases, Collins and Hillary, based on the majority of cases, and let's be clear, from the state of New York, when we're citing to the New York Supplement Second or whatever volume it is, every one of those are trial court orders, but every one of those are trial court orders, but in court orders, but in court orders, but in, and that wasn't done in this case. So I think there's some valuable language in Lopez, but the simple matter of the fact is the cases that talk about
What's this fire?
Sorry?
I don't know what that was.
I don't know why somebody's phone talking.
The internet.
Maybe
Turn the
so.
sound off. Or use an earplug. Come on.
The New York cases, again, deal with the issue of probabilistic genotyping. They have some great language in them that are worth reading for future reference when we get around to that exciting world of probabilistic genotyping, but it wasn't done here. One of the interesting things about this, Mr. Sachs and Mr. Marcus are not here. They're going to deal with the issue as it relates to the trial, but this is a Fry hearing. And if you recall, one of the things that I talked about at the very beginning in making an assessment about whether something is new and novel is how well accepted, obviously, the science is, and your opportunity to fully examine and deal with the underpinnings related to that science. And I made the comment that during the course of this month, we've had more than ample evidence demonstrating how well you can deal with the specific issue of underpinnings of this science in cross-examination. So much so that if there are any mistakes in the science, you can catch them right in the room. The idea that this is new and novel and that we're dealing with things that people are unfamiliar with is belied by all the evidence, all the testimony in this case, in this record. Mr. Moldoff reminded us a couple of times. Thought I was getting off topic, he said, because I need to focus on what his motion said. And I'm looking because I thought I had my copy. I'll do it as best I can from memory. In his I think it's his memorandum of law. Oh, thank you.
Wait a minute. Yeah, this was
And for some strange reason, this one, lucky for me, has no page numbers.
So our page 3, maybe your page 5?
Here's what I'll tell you. As you go through and reread the motion, it's interesting, and I think, and I don't want to use the term of Freudian slip, but it's an interesting observation that within the body of the motion itself, Mr. Moldoff uses the term, or uses words to the effect of, that he is not challenging, or Mr. Forbes is not challenging, the science and methodology. He's challenging how it was utilized in this case. We've talked about that on a number of different occasions, and I think Mr. Aronson was kind enough to give us what amounts to a national survey of all these different cases from all these different states dealing with this different issue. Let me give you, and I've provided copies after we came back from lunch. This is the first DCA, Searcy, S-E-R-C-E-Y, 825 Southern 2nd, 959. This is a case dealing with...
I'm not sure what you said.
Yeah, I haven't said it yet.
Even Siri wants to argue with me, huh?
Surrey objects.
Whose phone am I going to take?
I don't know.
No one's, it's fine. Siri was a case dealing with gas chromatograph mass spectrometry, GCMS. That wonderful instrument in the lab that they use to determine if something is a particular controlled substance. And there were some fraud-related challenges to the way the GCMS was used in trying to identify cannabis, or THC, in this particular case. Language from the case. In the clipped and highlighted portion, a couple of lines down. Under Ramirez, once the judge found the scientific principles and procedures underlying the expert's opinions regarding the presence of THC, and I think that is ETHC, in Circe's blood, and I'm going to leave out the parens, the threshold determination of admissibility of those opinions was met, and the judge was required to allow the experts to render opinions on the presence of THC and old eyes, CTHC, in Circe's blood, leaving for the jury to determine the credibility of those experts' opinions. The issue of whether the particular analysis of Circe's blood by Dr. Baselt, and that's B-A-S-E-L-T, apostrophe S, Baselt's lab, was performed in the proper manner, including whether sufficient quality control procedures were used to ensure the accuracy of the test results, was a question of credibility and probative value for the jury to determine after hearing the evidence of the experts. Consistent with those cases that I cited at the start of my argument from the Florida Supreme Court that talked about you're here to look at science. The defense wants to keep coming back to discussions and saying, we don't like the conclusions reached by these experts. We are not here, contrary to the arguments of the defense, to assess the character of expert witnesses. We are here to determine whether or not the science they employed and the methodology they employed is scientifically sound. All the witnesses say that it is, and for that reason, arguments attacking their character, to the extent that the defense can and wishes to do it, are matters for the jury on the issue of weight, not on admissibility. Mr. Aronson also went to Bryn in part of his argument suggesting that Florida, and I want to stay with Florida for the moment, says that you can't do a group hypothesis. You've got to have a number for the specific defendant. And he cites Bryn for that proposition. Bryn, in talking about likelihood ratios in a group, goes directly to the National Research Council report from 1996, NRC2 for short. During the course of this hearing, you heard portions of that, you heard testimony about that as it relates specifically to likelihood ratios. NRC2, the 1996 report, says group hypotheses are proper, and contrary to the argument of the defense, when you get a statistic for a proper group hypothesis, you have a number, you have a statistical number. You may argue its value, and I will give credit to Mr. Aronson that at length he does, and he's welcome to do that to the jury, to cross-examine the witnesses at length on that point. But this is not a Fry issue. The science is valid. NRC has been using it for 20 years, and the Supreme Court of Florida has validated and accepted that procedure in conformity with the National Research Council recommendations. He cited a number of different cases. The court made one observation, which, again, when you look at the cases, you'll make your assessment. Your question was, how many of these involve just one defendant?
Actually, I think I asked how many involve co-defendants.
The opposite. I think we just did a likelihood ratio, but we'll move on from there. He cites McNichol. And you'll forgive me because I don't have a copy of it in my hand at the moment. But he was citing language regarding the idea that it rejects a group hypothesis, that you cannot do it that way. But the language he read from has a footnote, footnote 18 in McNichol. And footnote 18 goes directly, not surprisingly, to the National Research Council, whose hypotheses expressly provide for group hypotheses. There's discussions about the Sweetdam guidelines. I read them directly in a part of my initial argument. They contemplate group hypothesis. The idea that this is now unaccepted science is rejected by the same organizations that they want to claim provide a basis for a challenge. I know there's a lot of talk about what a lot of different states say, but I'm going to go back to our DCA and what appears to be at least the most recent opinion dealing with that issue that I argued during the course of my initial arguments. And that's Mickens again, M-I-C-K-E-N-S. Mr. Aronson referenced it at 121 7 3rd 553. Citing and distinguishing itself from other courts, including federal authority. The Florida Supreme Court has been more lenient in allowing the admission of scientific tests which do not conclusively identify a defendant. Citing to the Walker case from 1998 from the Florida Supreme Court. I understand that there are some authorities, none of which, by the way, directly implicate this theory of a group hypothesis. But there are some states that may argue that you require more than what Florida does. In this case, as it relates to the group hypothesis, quite frankly, I've yet to see, and I've yet to see a case that supports the proposition that you have to break out defendants. There's no support for it. It's not logical. The probative question, and I'm going to jump ahead to Mr. Williams' argument now. Mr. Williams said, and I thought it was very interesting how he worded it, he said that the state is very subtly trying to use this evidence to support a conspiracy theory. There is nothing subtle about it. This is not subtle. These three men worked together, killed one officer and tried to kill a second. And to the extent that the physical evidence links all three of them together, no, I am not trying to do it subtly. I want to ring that bell in front of that jury, and I am allowed to ring that bell in front of that jury. Yes, it is prejudicial. As all these cases say, all of this evidence is prejudicial. The Florida Supreme Court, I'm trying to remember now, this is Amoros, A-M-O-R-O-S. I'm going to guess 588 Southern 2nd. I can't remember the page number, but it's the seminal case from the Florida Supreme Court that says, when doing a 403 analysis, every piece of evidence is in fact prejudicial to the defense. Otherwise, we might imagine the state wouldn't offer it. The question is the prejudicial effect. Not whether the prejudicial effect outweighs the probative value, but whether unfair prejudice outweighs. There's no unfair prejudice. Oh my God, of course it's prejudicial. Why in the world did we bother to ask the question? How is it not probative if it's not prejudicial? It's evidence of guilt. All evidence of guilt is prejudicial. There were some cases. I'm going to limit my reference to 3 of them. I actually have copies. I don't know if the copies you have are in 10-point type, in which case I hope you have your larger reading glasses if your eyes are anything like mine. But I have, Mr. Aronson on the break ran into me, was asking me about the judicial notice, whether or not I had copies of the cases that I had cited for judicial notice, and I was able to find some. And so I wanted to give. What's interesting about these cases, Mr. Aronson cites them for the proposition regarding group hypothesis. I think the evidence, again, does not support by any stretch of the imagination the argument he advances on the lack of scientific value. But there are a lot of other interesting observations in these cases about how you make an assessment in a Fry scenario when the evidence, in fact, is not new or novel. As in, you shouldn't be doing it. And questions regarding laboratory protocols and all these other aspects go to weight versus admissibility. I want to give I know you guys already have it, but I want to give you a copy that's identical and highlighted and clipped the way I give it to the judge. This is Garcia. The site should already be on the record, but let me do it anyway. 3 Pacific 3rd, 999.
If you want the Amoros, it's 531 Southern 2nd, 1256.
So the 88 I'm thinking of is the year, 1988?
Give you partial credit on the answer.
I'm slipping. And this is Ayers, A-Y-E-R-S, 58 Pacific 3rd, 768.
Don't we have that one?
I think
Andy, didn't you use it?
I think he's giving you both of these. I'm just giving you a copy that's printed in 14-point type or 12-point type.
I gave you both of these cases. In fact, I think every case Scott's going to give you, I've given you.
Yeah.
Okay.
This is from Montana.
Yeah, Arizona. Montana has 2 cases a year.
That many, huh?
Maybe.
Here's what we can say. It's 420. As I started this argument, you've heard the evidence, you've heard the arguments from the lawyers, and you've asked for a memo by, I think it's April 24th.
I would hope it's not April 24th.
May.
Well then, forgive me if I'm a month late, but May 24th.
I think on April 24th we were still...
I said I would try to do it in less than 15 minutes, and I think that's more than enough.
That's fine. Mr. Moldoff, you have anything further?
Judge, I just wanted to remind the court of the, in light of Mr. Aronson's argument and in light of the issue, the niche vision evidence that we have that shows how, I mean, that was something that was, I thought, very demonstrative of what Ms. Wood was talking about, where we had those likelihood ratios that they say is absolutely permissible. And, you know, not to forget Ms. Wood's testimony as well, but certainly that particular example, when it's in evidence and you can read it, where when they, you know, I mean, they really can't complain about it. The state attorney's office sends it to niche vision to see now the likelihood ratios now broken down by what the state says they can't do, but what niche vision does with STR mix genotype software and breaks it down individually to see if Gibson's really included, and comes out with the statistic that it's more likely he's not included. So if that is as a hard example of what we've been talking about, again, the state gives you nothing other than this is not new and novel, but it absolutely is new and novel. If here we are in 2016 and the Hillary case in New York is looking at STR mix and having to analyze this and saying, here's another example of how it's not that the science is new and novel, but the application of the science is new and novel when they now start getting smaller and smaller samples and different labs operate differently. That's exactly what our complaint is. A BSO lab, as a contrast with how Tracy and McElfresh interpret it, that's new and novel. What they're doing, nobody does. New and novel is using the LR mix as a calculator. Not only new and novel, it's never heard of. So for them to say there's nothing new or novel here really begs the question, how can they say that when even Tracy McElfresh admits it? So, standing on that, that's all I have.
Aaron?
Just a couple of things in response to Mr. F. First of all, the motion that I was arguing by and large, and certainly I did argue a little bit about Mr. Moldoff's motion, by and large, mine is a motion in limine. And the only time to have heard that is the way you have done it. Because can you imagine what would have happened in trial if they put on Dr. McElfresh and we said we want to voir dire the witness, and 3 weeks later we were done with the voir diring of the witnesses. So I think pre-trial, the way we've done it is the proper way and the only way to do it. And I don't think we're going to come up with any other testimony that's going to change whatever ruling you make on this. So I think our motion was timely and done in the proper form. As to Mr. F. citing Grimm and talking about LR, likelihood ratio, Grimm is a random act probability case. And that's the only thing I want to say. I don't even think the word likelihood ratio is in the decision. Maybe wrong the vision is going at this age, but I don't think it's an LR case. I believe it's a random act probability case. And the state cited back to McNichol. I cited McNichol because of that one proposition. But what you need to understand is McNichol was overruled and overturned by Matai. And so what they say in Matai pretty much is, in McNichol's, they didn't raise the issues that Matai did as to whether you could use these types of calculations. I cited it because it still talked about the individual. But Matai is controlling over McNichol's, and if you read the cases, you'll understand very clearly. And the state also cites to Mickens, and they say that Mickens says you do not have to conclusively ID the defendant. We agree with that. That's why you'd need to put a number on it. Conclusively would be, it's him. That's conclusive. Not conclusive is his DNA is in the mixture, and 1 in 30. That's not conclusive. That's a statistic. Mickens does nothing for the state as far as bolstering their argument. It's just saying what we've already been saying, that if you're not going to say it's conclusive, you give a numerical weight to the association for the individual. And I don't know if Mr. Williams is going to say anything, but if he's not, what I'd like the court to know is that as far as whatever memo I gave you, it's going to be what I brought. I don't think it could add anything. So if you're going to get the transcript, you have my memo.
Could I, however you want to do that, regarding the memo, I was kind of feeling the same way. I don't know if the court still feels the same way about wanting that.
If you guys have already submitted, that's fine. If you want to supplement them, that's fine. That was really what I was getting towards. But Mr. Williams, would you like the last word?
No, I'm going to supplement because I agree with Mr. Aronson. My objection is more in the nature of motion in limine as to whether the substantial prejudice outweighs the probative value with the way they apply the analysis.
Well, the one thing I appreciated about Danny's last couple of comments were that we're not doing this for 3 weeks in front of a jury on a voir dire.
And we would have.
Anybody else on these motions?
Done.
Well, I got to tell you, this is the most well-behaved you guys have been in the entire.
It's because that Sats guy, he's just
Wow. Look who's not here. You're not recording this.
I will see you guys on the 6th, unless there's an emergency that I need to deal with on the 5th.
Have a great